Good morning to everyone. On the part of the Committee on Good Government and Public Accountability, this meeting is now called to order.
Good morning, ladies and gentlemen. On the part of the Committee on Justice, this hearing is now called to order.
Representative Bominal.
Mr. Chair, good morning. In behalf of both committees, the Committee on Good Government and the Committee on Justice, I move to dispense the reading of the calling of the roll and the reading of the minutes of the previous meeting.
Any objection? The roll call is hereby dispensed with. Good morning, my colleagues, and of course, Secretary Aguirre, and our guests and resource persons. The first item in our agenda under the deliberation proper is the joint deliberation by the Committee on Good Government and Public Accountability and the Committee on Justice on House Resolution number 867, sponsored by Speaker Pantaleon Alvarez. The resolution called for an inquiry in aid of legislation on the alleged grossly disadvantageous contract entered into by the Bureau of Corrections and Tagum Agricultural Development Company, Incorporated, also known as Tadeco. House Resolution number 867 sought to inquire whether or not the joint venture agreement between BuCor and Tadeco involving the lease of a portion of the Davao Penal Colony is grossly disadvantageous to the government. We have invited resource persons from the Department of Justice and BuCor to provide us information on the terms and conditions of the agreement and the status of the execution. Officials from Tadeco and Amplocor were invited to present their position on the issues brought before the joint committee. We also sought the assistance of the Solicitor General and Securities and Exchange Commission on legal and technical matters within their respective expertise. We have also in attendance interested parties to the BuCor and Tadeco agreement. The mandate of the Committee on Good Government and Public Accountability is to find out whether or not the execution and implementation of the subject joint venture agreement in its amendments were in accordance with existing laws, rules, and regulations, in that it did not work to the disadvantage of the government. Otherwise, the committee will determine whether or not government officials and employees tasked to implement the law and protect the interest of the government committed malfeasance, misfeasance, or nonfeasance to the performance of their duties. At the final analysis, the committee will recommend necessary remedial legislation to address the issues referred to the jurisdiction of this joint committee. I will now give the floor to Representative Reynaldo Umali, the Chairman of the Committee on Justice.
Thank you, Chairman Pimentel. Good morning, the Chair of the Committee on Good Government and its members. Good morning also to distinguished members of the Committee on Justice. Thank you very much, Manong Johnny, for taking the lead in this investigation because this really is the concern more of the Committee on Good Government than of the Committee on Justice, which is more concerned of its jurisdiction on penal institutions and educational and reforms needed under the correctional pillar of our criminal justice system. So, in fact, I'd like to inform the body that we have already started conducting our own investigation, as we did, in fact, when we conducted the inquiry or investigation on the proliferation of drug trade in the New Bilibid prison, and we have made recommendations there too, which we would like now through this joint hearing, the Secretary of Justice should be able to clarify, and in particular in the Bureau of Correctional Modernization Law, what has happened to it, especially in the light of the requirements, financial requirements in implementing the BuCor modernization law, when we have all of these incomes or revenues being received by the BuCor, that is not too clear on how this is accounted for, how this is covered by the general fund, how this is disbursed by either the Department of Justice or the BuCor. We would like to know what is happening to these funds, because the requirements in the modernization of the Bureau of Correctional is really something that while we have passed this law in 2013, nothing has happened to it, and mainly because of financial constraints, because of the financial requirements in the operationalization and execution of the BuCor modernization law. So I'd like, of course, to thank the Speaker for filing this resolution that will open up and give us insights on how best we can get more resources to fund the BuCor modernization law. So that is our beef, the Committee on Justice beef in this particular joint congressional hearing. And so again, good morning to everyone, and I now give back the floor to Chairman Pimentel.
Thank you, Chairman Umali. Before we proceed, I'd like to acknowledge the presence of the members of the House of Representatives and members of the Joint Committee. Deputy Speaker Gwendolyn Garcia, Representative Gabriel Bordado, Vice Chair for Good Government and Public Accountability, Representative Winston Castelo, Representative Rodante Marcoleta, Representative Emmanuel Briones, Representative Leopoldo Batawil, Representative Henry Waminal, Representative Pablo Ortega, Deputy Minority Leader Eugene De Vera, Representative Ariel Casilao, Senior Deputy Majority Leader Juan Pablo Bondoc, Representative Harry Roque, Deputy Minority Leader Alfredo Garbin, Deputy Minority Leader Anthony Bravo, Representative Roger Mercado, Representative Carlito Marquez, Vice Chair for Good Government, Representative Limuel Fortun, Representative Jonas Nograles. Before we proceed to the next agenda, we have invited 23 resource persons. And I would like to mention their names, and once your name is mentioned, please acknowledge. Secretary Vitaliano Aguirre, Secretary of Department of Justice, thank you, sir, for coming. CEC Ricardo V. Paras III, Chairman, DOJ Investigating Panel. Director Maria Charina Buena D. Po, Vice Chairman, DOJ Investigating Panel. Is she present? Okay. State Precious Rojas, Member, DOJ Investigating Panel, present. State Counsel Melvin Suarez, present. Attorney Catherine Angela Maralit, present. Attorney Benjamin De Los Santos, of the BuCor. Solicitor General Jose Calida, or any representative from the Solicitor General's office? None. PIS Gerardo Padilla, Acting Superintendent, Davao Prison and Penal Farm, BuCor. Present. Mr. Anthony Valoria, President CEO, Tadeco. Present. Mr. Oscar Grapa, Chief Finance Officer, Tadeco. Absent. Mr. Anthony Sasin, Inflow Management and Investment, present. Ms. Maria Teresa Florendo, Anflocor. Ms. Maria Linda Lagdemeo, Anflocor. Absent. Maria Cristina Brias, Anplocor. Mr. Ricardo Florendo, Anplocor. Present. Mr. Vicente Florendo, Anplocor. Absent. Miss Emilita Aguirre, Tadeco. Miss Elsa Gutierrez, Mr. Lorenzo Estrella, Representative Antonio R. Florendo Jr. I'd like to inform the members of the two committees. Representative Antonio Florendo has sent a letter. I'd like to read to you the content of the letter. Dear Chairman, the scheduled hearing on the joint venture agreement with the Bureau of Corrections and Tagum or Tadeco will be a good opportunity for me and the company to correct all baseless and misplaced accusations leveled against it. However, being a member of the Committee on Justice, which will jointly conduct the investigation with the Committee on Good Government and Public Accountability, I deem it more prudent to rescue myself from participating in the investigation to obviate any perception of personal interference or influence on the outcome. Rest assured that I will support all other undertakings that your committee will initiate, except activities that in any manner related to or connected with my family's financial or business interests. Thank you very much. Signed, Antonio R. Florendo, Jr. I would also like to recognize the presence of our Majority Floor Leader, Rodolfo Fariñas, Representative Jerry Treñas.
Mr. Chair?
Yes.
Yeah, at this juncture, may I just also recognize the members of the Committee on Justice, Vice Chairman Henry O. Minal, Congressman Jericho Nograles, Congressman Lawrence Fortun, and Congressman Rodante Marcoleta. Of course, we would also like to recognize the ex-officio members of the Committee on Justice, Congressman Gwen Garcia. We have already recognized the Majority Leader. We have also Senior Deputy Majority Leader Rimpi Bondok, Congressman Roger Mercado, Congressman Alfredo Garbin, Eugene Michael De Vera, Anthony Bravo, and Harry Roque of all of the Committee on Justice.
Members of the Joint Committee, for the meantime that the sponsor, Speaker Alvarez, is not yet around, if there is no objection, I would like to, or rather we can proceed to item number B, the preliminary determination on the following referrals. If there is no objection. Any comment from the members? Okay, since there is no objection, we go to item number P, preliminary determination on the following referrals. House Resolution number 753. The Committee on Good Government and Public Accountability will now, for the meantime, while we are waiting for the presence of Speaker Alvarez, proceed to the second item of the agenda under deliberation proper. The committee will consider for preliminary determination the following referrals. House Resolution number 753, introduced by Representative Henry S. Waminal, calling for an inquiry in aid of legislation into the reported procurement irregularities committed by the officers of the Government Service Insurance System on the stoppage of the construction and demolition of the GSIS Quezon City branch office in Elliptical Road, Quezon City, referred to the committee on March 7, 2017. Number 2, House Resolution number 6767, introduced by Representative Harry Roque Jr., calling for an inquiry in aid of legislation on the alleged corruption and irregularities in the operation and business of PhilHealth, referred to the committee on March 7, 2017. The conduct of a preliminary determination on measures referred to the committee is found in Rule 4, section of the internal rules of the committee. It intends to give direction to the committee deliberation for expediency and order. Primarily, the committee will determine its jurisdiction on the measures referred to the committee. The committee will also clarify and define the issues raised, give the authors or sponsors of the measures the opportunity to ventilate their concerns. Resource persons to be invited and documents necessary to settle the issues presented will be identified to prepare the committee in proceeding with the inquiry, in aid, of course, of legislation. We'll now proceed with the preliminary determination. I'll now give the floor to Representative Henry Wiminan.
Thank you very much, Mr. Chair. Good morning to everybody. This humble representation filed this House Resolution number 753, which resolution which directs the Committee on Good Government to conduct an inquiry in aid of legislation into the reported procurement irregularities committed by the officers of the GSIS that leads to the stoppage of the construction and eventually the demolition of the GSIS Quezon City branch office situated at the Elliptical Road, Quezon City. This GSIS project, Mr. Chair, had this been continued and completed, the cost of the building could have been 250 million pesos, paid at the current price of 45 to 50,000 per square meter. The contract cost at that time was only 14,000 per square meter, which was only about 65 million pesos. So the GSIS, the government, stand to lose about 190 to 200 million pesos. The building was not completed, which would now be the subject to this inquiry, and worst, it was demolished, and when it was demolished, the GSIS stand to lose of not less than 40 million pesos, the actual amount paid by the GSIS to the consultant and to the contractor. That is the vision of this inquiry, Mr. Chair, that there appears to be a malfeasance, a misfeasance in the performance of duties of our public officials. It is in this context, Mr. Chair, that I move that this committee will proceed with the investigation of this, and inquiry of this House Resolution number 753. And upon its approval, this representation would request for the invitation of the President of the GSIS, the President Auditor of the Commission on Audit assigned to the GSIS, and the Chairman of the Commission on Audit, Chairman Aguinaldo. And in addition to that, Mr. Chair, I pray that the committee would require the GSIS to forward to this committee the documents related to the procurement of this Quezon City GSIS building project.
Any second on the motion? Yes, Representative Castello.
Clarification on the suggestion of Congressman Minal. Would the invitation only be limited to the sitting directors of the GSIS, or will also involve personalities of the GSIS when the contract was perfected?
Well, I would prefer that the current leadership, because the demolition of the building happened with the current leadership of the GSIS. I'm referring to President Vergara, because the demolition was made, I think, during 2011 or 2012. I do not know whether he is already replaced. No. So I wouldn't prefer that the current leadership, the GSIS, who would probably enlighten us on the actions taken of his predecessors. And later on, if it is warranted, we can probably invite the previous officers of the GSIS.
Mr. Chairman, please. Would,
Yes, Senator Costello.
would the representative of Misamis Occidental be only interested on the demolition of the building or the legalities surrounding the contract?
As cited in the resolution, it is also the circumstances that lead to the stoppage because, as I said, had the project been completed, it would have cost now 200 to 250 million, pig at 50,000 per square meter.
We submit, Mr. Chairman. Thank you very much.
Any second on the motion of Representative Bominal? Seconded. Any objection? There being none, the motion of Representative Bominal is hereby approved. We will have to suspend the deliberations on House Resolution number 767 because Secretary Aguirre has another appointment at 11 o'clock. So if it's okay, Representative Roque will go back to item number A, letter A, which is the preliminary, or rather deliberation proper of House Resolution number 867. Pursuant to Section 9 of the Rules of Procedure governing inquiries in aid of legislations, witnesses shall testify under oath. So therefore, may I request all the resource persons to please stand to take your oath. And I'm authorizing the COMSEC, Attorney Marivic, to administer the oath. May I request the resource persons, please, to stand?
It's okay, sir. Please raise your right hand. Do you swear to tell the truth, the whole truth before this joint congressional inquiry? Thank you. You may sit down.
Before we proceed with the interpellations, although the speaker is not yet here, but considering that Secretary Aguirre will be having another appointment, so may I remind all the members that we have an order of interpellations, so may I request the members to have your names listed. We'll now proceed with the first interpellator.
Before that, Mr. Chair, may I know if all the resource persons invited are here? Because I think we have to dispose of that particular issue also on those who are not present. I understand that when the resource person, when the names of the resource persons were called, some of them did not acknowledge.
We have at least 1, 2, 3, 4, 5, 6, 7, 8 persons that are absent, as we have called their names earlier.
Yes, in the case of one resource person, Mrs. Lagdameo, I got a call from former Congressman Anton Lagdameo, who informed me that his mother cannot attend because she is out of the country, and therefore perhaps another invitation is appropriate in the case of Mrs. Lagdameo. But in the case of the others, Deputy Majority Leader, what is your pleasure?
Representative Bondoc is recognized.
Mr. Chairman, honorable colleagues, esteemed guests, may I begin now a simple interpellation for
No, we'll first take action on the comment of Chairman O'Malley.
Mr. Chairman, could we now ask for a show cause order regarding those who were not able to attend but who were properly invited, as has been the previous practice of the Committee on Good Government, that those who are invited should show cause why they were not able to give time to the invitation of the committee, and thereafter, should there be a need, be subpoenaed to appear before the esteemed committee.
Noted,
Chairman.
Representative Bondoc, I'm hereby directing COMSEC to please issue the show cause order or letter to the resource persons that were absent, informing them, or rather, absent for today's hearing.
Mr. Chair, how do we
Representative
treat
Romero.
those invited resource speakers, resource persons who have answered in writing, and the one that also made a call to the chairman of the Committee on Justice? How do we treat such communication?
Actually,
Will they
there
be
are-
included in the show cause order?
Representative Bominal, actually there are only two resource persons that have signified their explanation. One is rather Congressman Tony Boy Florendo, who sent a letter, and of course, Ms. Linda Lagdemeo, who was able to talk to Representative O'Malley.
So they will not be included in the show cause order invitation.
Probably in the invitation na lang.
And Mr. Chair, I wonder why in the list of invited resource persons, the Office of the Solicitor General is not invited, is not one in the
He
list.
is invited. The Solicitor General is invited.
What number? Of
Number
your
9, Solicitor General Jose Calida. But unfortunately, sa Solicitor General Jose Calida is not present and has not sent any representative also.
So he
So
should be
he will
included
be
in
he
the
will
show
be
cause order.
included in the show cause order.
What about the Commission on Audit, Mr. Chair? Why is the chairman of the Commission on Audit not invited in this committee hearing?
According to COMSEC, the list of
Walang number 9,
resource
42.
persons was submitted by the sponsor himself. So, with regards to the list did not include Chairman Mike Aguinaldo.
So can we include in the next hearing to write an invitation to Chairman Aguinaldo of the Commission on Audit?
Is there any objection from the members to
Mr.
include?
Chairman. Mr. Chairman, I modify my previous motion. Following practice on the Committee on Good Government, those invited that did not give any reason for their absence should now be subpoenaed to appear before the committee. I so move, Mr. Chairman.
Any second? So there's amendment rather to the suggestion of Representative Bondoc. Instead of show cause orders, the resource persons that are absent today will not be issued show cause order, but rather they will be subpoenaed for the next hearing. Any objection? None. Motion is hereby approved. I believe that the members already know the hearing. Can I request the members or the interpellators to focus on the questions to Secretary Aguirre? We'll give him priority because he will be leaving in about, or rather around 11 a.m. Majority Floor Leader, do you have any questions to Secretary Aguirre? Any opening remarks? Secretary Aguirre is recognized.
Thank you, Mr. Chairman. Good morning, Honorable Johnny T. Pimentel, Chairman of the Committee on Good Government and Public Accountability, and Chairman Reynaldo Umali of the Committee on Justice. Good morning, Majority Floor Leader Rudy Pareñas, Vice Chairman, and members of the House present today in this committee meeting. Magandang umaga po sa inyong lahat. Actually, we have sent a letter to the leadership of the House in connection with our recommendation on the a way of reply to the letter sent to us by the Honorable Speaker Bebot Alvarez. And I would like to read our recommendation after which we are ready to answer some questions together with our Chief State Counsel, Chief State Ricardo Paras III, and USEC Richie Ko of the Department of Justice. So, without further ado, may be allowed to read our recommendation contained in the letter to the Honorable Chairman of the Committee on Good Government and Public Accountability, dated May 8, 2017. This is in connection with the BuCor-Tadeco joint venture lease agreement. And may I quote, "In view of the foregoing, the Department recommends 1. Revocation or rescission of the contract by the President of the Philippines pursuant to Section 1A of PD number 1585, entitled Prescribing Certain Standards, Conditions for Government Contracts, Concessions, Licenses, Permits, Leases, or similar privileges involving exploration, development, utilization of natural resources." It is the stand of the Department of Justice that these 5,300 plus hectares, the subject matter of the BuCor-Tadeco joint venture or lease, as the case may be, cannot be a subject matter of contract in view of the fact that this is beyond the commerce of man. And number 2, the Department of Justice to instruct the Bureau of Corrections to file the appropriate action in court for the declaration of nullity of the JBA or lease, as the case may be. And number 3, a proclamation be issued by the President reclassifying the Davao Prison Penal Farm, DPPF, as alienable and disposable land before the Bureau of Corrections, as may be allowed to enter into an agreement and for the concession of the said property, subject to the public bidding requirements under the law. We believe that if ever there is an entity who would be able to, who has the right to question the contract, it would be the Bureau of Corrections, because it's one of the contracting parties to the said agreement. And we are aware also of the many individuals who are supposed to be workers in this the farm of the or the penal farm of the Bureau of Corrections, and in order that they may not be there will be out of work, so to speak, in this parcel of land, we would like to recommend that the President reclassify them into an alienable and disposable land, in order that the BuCor or the government will be able to enter into contract with other entities in accordance with the Constitution and in accordance with the Public Land Act. So,
Thank you.
if there's any questions, my Chief State Counsel and the USEC Richico and the others and your humble representation are willing to answer them.
Thank you, Secretary Aguirre. Before we proceed, I'd like to acknowledge the presence of our Speaker, Speaker Pantaleon Alvarez, Representative Orestes Salon, Representative Carlos Isagani Sarate, Representative Doy Lichon, Vice Chair, and Representative Baby Arenas. The Chair will now give the floor to Speaker Pantaleon Alvarez. So,
Mr. Chairman, since the Department of Justice has already concluded with their findings and our recommendations as to the issue at hand, and for us to be guided accordingly by the findings of the Committee of the Department of Justice, may we request that a copy of the said findings be furnished to all the members of this committee and to all the members present. Thank you, Mr. Chair.
noted. Secretary, can we have a copy also of that recommendation to be submitted to the COMSEC?
Yes, Mr. Chairman, we'll be filing a copy thereof, but we would like, because after our trip with Congressman Chairman Reynaldo Mali to the United States in connection with our JBC observation tour, it was only upon my return that I was able to be given an opportunity to review the main opinion. I found some
Hindi mo sinama yung mga bodyguards.
findings or conclusions in the body to be that need to have revision. But in the meantime, Your Honors, we will be submitting to you our letter to Chairman Pimentel with a
Mr. Chair,
summary of our opinion as well as the recommendations that I have read.
Mr. Chair, a quick reaction to the manifestation.
No, we
made by the
first
Secretary.
recognize Representative Bondok. Representative Bondok is now recognized.
Thank you, Mr. Chairman. Good morning to the Honorable Speaker. Mr. Chairman, at this outset, I would like to thank the Secretary of Justice for taking time out with the complete team from the Department of Justice to appear before this committee. My questions were more procedural, Mr. Chairman, and have been addressed by the Honorable Garbin. We do not have copies of the letter as read by the Honorable Secretary of Justice. I was hoping to ask for copies of that. And with that, a matter he has also touched on, what is part of our material is a letter to the Speaker of the House, marked April 27, 2017, received from the preliminary fact-finding report. It is signed by Undersecretary Raymond Mecate. And I was hoping to ask the Secretary of Justice, this letter, which has findings regarding the issue at hand, are still subject to his final review and recommendations. So this letter of his, which he has read and which we do not have a copy of, sustains actually the report of the Undersecretary. But as he has stated, he has more to say by way of corrections and review on the matter. So we await the letter as read by the Honorable Secretary to shed light on what will be his final assessment and the assessment of the Department of Justice on this matter at hand. Thank you, Mr. Chairman.
Thank you, Representative Bondok. The Secretary has already signified his willingness to submit the recommendations once he has already reviewed it.
No further questions, Mr. Chairman, and we await a copy of the letter as read today by the good Secretary and his further recommendations.
May I now recognize Representative Bordado for his interpellation?
Thank you, Mr. Chairman. My questions should have been directed either to Tadeco or to the Bureau of Correctional, the BuCor. But, Mr. Chairman, let me also address my question to the Secretary, the Honorable Secretary Aguirre. In the letter sent by the Solicitor General Calida, dated April 25, 2017, he stated, Mr. Secretary, that it should be emphasized that the Constitution provides that private corporation may only hold lands of the public domain through lease for a total period not exceeding 50 years. and not to exceed 1,000 hectares. Since the joint venture started in 1969, Tadeco's use and occupation of the DAPECO lands, or the Double Penal Colonies lands, should immediately cease in 2019, Mr. Secretary.
That's correct, Mr. Chair.
In other words,
Your Honor.
according to the letter, the consolidated JVA cannot be allowed to last until 2029.
That's correct, Your Honor.
The constitutional infirmity of the consolidated JVA is highlighted further by the fact that it covers 5,212.6 hectares, which is way more than what is allowed in the Constitution, Mr. Secretary.
That's correct, Your Honor. As a matter of fact, I think it is 5,308, the current subject, the area of the land now, Your Honor.
Okay, thank you, Mr. Secretary. And there was this statement too, Mr. Chairman. Assuming that the agreement falls under the definition of lease under the Civil Code, the consolidated JVA would still be void since it failed to comply with the competitive bidding required in CA 141. Is that correct, Mr.
That's
Secretary?
correct, Your Honor. That's the position of the Department of Justice.
Okay, thank you very much, Mr. Chairman.
Thank you, Representative Bordado. May recognize Representative Marcoleta.
Thank you very much, Mr. Chair. Mr. Secretary, good morning po.
Good morning po, Your Honor.
In the fact-finding report submitted by your office, signed by Undersecretary Mecate, there is a finding here, Mr. Secretary, that the Davao Reservation, being inalienable land and of the public domain, is a property which is outside the commerce of men. Hence, it cannot be subject of even a joint venture agreement such as the one entered into by BuCor and Tadeco. This is confirmed, Mr. Secretary.
This is one, that's generally correct, Your Honor, but this is one of the provisions which I want further study and revised, because I think the three constitutions are coming or are into play here: the 1935, the 1973, and the 1987 Constitution, which have different provisions in connection with the utilization of none of our natural resources.
Mr. Secretary, to me, this is the most, I think this is a very significant finding because it is based on Commonwealth Act number 141.
That's correct.
Or the Public Land Act.
That's correct, Your Honor.
Which to this day, Mr. Secretary, is still the existing general law governing the classification and disposition of lands of the public domain. As a matter of fact, in Section 6 of this law, it empowers the President to classify lands of the public domain which prior to such classification are inalienable and outside the commerce of men. So several questions will crop up, Mr. Secretary. First of all, this is a reservation. Has there been a presidential directive or action converting it into alienable or disposable public land? Because if there is none, then it is indeed beyond the commerce of men. And whatever contract, whether it is JBA, agreement, or leasehold, or whatever, it's no moment at all. Because unless Bucor or Tadeco will be able to produce that this reservation was converted into alienable and disposable public land, there is nothing more to argue. That's the first question. Number two question, I found it a little bit strange that, because there's also a report from COA, Mr. Chair, the COA has another appreciation of the JBA. The COA, Mr. Secretary, is invoking Republic Act number 1189 and seems to consider the JBA, not a JBA, but it's a form of leasehold and shared tenancy agreement. Do you think this appreciation is correct, Mr. Secretary?
Your Honor, to the first question first, that under the Public Land Act of 141, the lease is prohibited or other disposition in connection if it involves inalienable public land. Under Section 688, it is stated that tracts of land reserved under the provisions of Section 83 shall be non-alienable and shall not be subject to occupation, entry, sale, lease, or other disposition until again declared alienable under the provisions of this Act or by the proclamation of the President. So far, Your Honor, we are not aware that this inalienable public land has been declared as alienable and disposable by the President. And so the character of this land remains inalienable. Now, with respect to the COA findings, that this is the review of the contract is that the same is a lease agreement and not a joint venture. We are of the same position, Your Honor, that this lease contract prohibited under the said Public Land Act, Section 88.
Mr. Secretary, I'd like to point out the Section 42, which was quoted by COA, and it seems to me that Tadeco will not even fit as a tenant. As a tenant lessee, because under Section 42, Mr. Secretary, the tenant lessee should be the one who tills, cultivates, or operates the land susceptible of cultivation by one individual personally or with the aid of labor available from his own immediate household. Is a tenant lessee. So I don't think Tadeco is cultivating or enjoying the land or tilling the land with the help of their own immediate members of the household. I think this is a corporation, and they have a lot of farm workers and laborers, not necessarily coming from the immediate members of their family. So, on that score alone, Mr. Secretary, Tadeco will not fit as a tenant lessee. So, I don't think the appreciation of COA is accurate. Secondly, Mr. Secretary, I think you should draw your attention on Section 63 also of Commonwealth Act number 141. Because there is another, it seems to me that there is another criteria before a public land can be leased by a private corporation. It says here that whenever it is decided that lands covered by this chapter are not needed for public purposes, the Director of Lands shall ask the Secretary of Agriculture and Commerce, now the DNR, for authority to dispose the same. Upon receipt of such authority, the Director of Lands shall give notice by public advertisement in the same manner as it is in the case of leases or sales of agricultural public land. Has there been fulfillment of this condition, Mr. Secretary, where there is a categorical directive coming from the DNR that the leased property of Tadeco from BuCor is not needed for public purposes. Until and unless this is done, it cannot be leased because there is a conditionality that must be fulfilled in the first place.
I would like to agree with His Honor, but this is precisely the particular issue that I want to study. Because under Section 2 of the 1987 Constitution, it seems that the Constitution allows such utilization, but still we believe that this contract between BuCor and Tadeco is still unconstitutional. May I read to you Section 12 of the Section 2 of the Constitution under the 1987 Constitution. Section 2. All lands of public domain, water, minerals, coal, petroleum, and other minerals, oils, all forces of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state, with the exception of agricultural lands. With the exception of agricultural lands. All other natural resources shall not be alienated. The exploration, development, and all utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreement with Filipino citizens or corporations or associations at least 60% or whose capital is owned by such citizens. Such agreement may be for a period not exceeding 25 years, renewable for not more than 25 years, and under such terms and conditions as may be provided by law. In cases of water rights for irrigation, water supply, fisheries, or industrial uses, other than the development of water power, beneficial use may be the meaning of the limit of the grant, etc. So, under this provision, this, I think, was overlooked in the initial opinion that the Department of Justice prepared, and for which reason we would like to include this in the study and in the opinion to be given by the DOJ to these honorable committees.
Thank you, Secretary. There's no debate there. Of course, what I'm really trying to point out here is that considering that this is a reservation and then converted into a penal colony, then the clear public purpose is for the BuCor to use it for as requirements of the Bureau of Prisons. And so before it can be leased to private corporations, that public purpose must be declared that it is no longer used, or some of it cannot be used for that purpose. Otherwise, it cannot be leased. This is because this is a conditionality under Section 63 of Commonwealth Act number 141. And also because this JBA and other agreements started in 1969, I think the applicable fundamental law is the 1935 Constitution, and it says that it cannot, private corporation or association may acquire, lease, or hold public agricultural lands in excess of 1,024 hectares only. That's the cap, that's the limitation. But if it is true that the total lease area now amounted to 5,308, then this is again a clear constitutional violation, Mr. Secretary. I hope you will be able to factor in these inputs. Thank you very much, Mr. Chair.
Thank you, Representative Marcoleta. Please, if you have any comments. Secretary Aguirre.
Thank you, Mr. Chairman. I tend to agree with the Congressman Marcoleta. And in the preparation of our revised opinion, we are going to take into consideration the points raised by the good congressman.
Thank you, Secretary. Before we continue, may I acknowledge the presence of Representative Albi Benitez, Representative Cesar Sarmiento, the Chairman, Committee on Transportation, Deputy Majority Leader Aurelio Gonzalez. May I remind the next interpellators, because of time constraints, we will have to set
Ferdinand Hernandez.
Deputy Speaker Ferdinand Hernandez also. We'll have to set a time limit of 5 minutes. Anyway, there will be a second round of interpellations. Next to be recognized will be Representative Henry Waminal.
Thank you, Mr. Chair. Mr. Secretary, in your position submitted to this committee, based on your initial findings, you said that the Davao Prison and Penal Farm Reservation, being inalienable land of the public domain, is outside the commerce of men. Thus, it cannot be the object of a joint venture agreement. But you further said, assuming that the lands can be the valid object of a contract, the 2013 agreement is not a joint venture under jurisprudence in the case of heirs of Tan Inki versus Court of Appeals, because the agreement lacks the following requirements to be valid GBA: no community of interest in the business by both parties, no categorical indication of a true and realistic sharing of the profits and losses. BuCor's participation is substantially minimal, as even the appointment of a BuCor representative in the management team of Tadeco has been deleted and no longer incorporated in the GBA. Am I right, Mr. Secretary?
Yes, Mr. Vice Chairman, we agree with you, and as a matter of fact, it will not be touched in the revision. We hold the same position, Your Honor.
Okay. The Office of the Solicitor General is under the Office of the Department of Justice.
Not really, Mr. Chairman. As a matter of fact, if Solicitor General Calida is here, he would object to that. Because actually, the Office of the Solicitor General is only attached to the DOJ by way in the budgetary, for budgetary purposes.
Anyway, the Office of the Solicitor General has rendered an opinion that the GBA is violative of Commonwealth Act 141, also known as the Public Land Act, because joint venture is not one of the 4 forms of concession or disposition of public agricultural land under Section 11 thereof, namely for homestead settlement, by sale, by lease, by confirmation of imperfect or incomplete titles, either through judicial legalization or by administrative legalization. Do you agree with the opinion of the Solicitor General?
Yes, Mr. Vice Chairman. Actually, that is the area which I would like to review, because the 1987 Constitution, if it is in conflict with the Public Land Act of 141, of course, the Constitution will prevail. So I reserve my opinion on this particular point.
Okay. And you furtherly said that the validity of the GBA can still be impugned on other legal grounds. One,
That's correct.
that based on the factual data, it is more than 5 times the allowable area under the present Constitution.
That's correct, Mr. Vice Chairman.
That there was never a public auction or bidding as provided for under CA 141.
That's correct, and we still stand on those 2 points.
That the GBA should expire in 2019 and not 2029, considering the 50-year limit under CA 141.
It is our position until now.
And under item 13 of the 2013 GBA, which gives Tadeco the option to remove plants, equipments, violates Section 38 of CA 141, which provides that upon the final expiration of the lease, all buildings and other permanent improvements made by the lessee shall become property of the government,
That's correct. We stand by that, Your Honor.
and that the current JVA does not include any of the required provisions that ensure government control over the land.
That's correct, Your Honor. As a matter of fact, the Section 2 of the 1987 Constitution states that control of the government must be secured.
And that finally, you insinuated that the contract was onerous because the 2016 production and profit share of BuCor amounted to Philippine pesos 44,834,726 or barely 8,449.83 centavos per hectare, compared unfavorably to the 10,000 to 18,000 prevailing lease rates per hectare of Tanglaw and cooperative leaseback rates located in the general area where the Davao Penal Colony lands are located.
That's correct, Your Honor. And considering that it is our opinion that although denominated as joint venture, this lease contract, then we could compare this with the rates in the surrounding similar areas.
And that this contract entered into between Tadeco and BuCor was duly approved by the Secretary of the Department of Justice.
I have, that's another I would like to verify on that because I believe that the Secretary of Justice did not approve this, only a USEC, but I don't know under what circumstances was that USEC approved this contract. So if the USEC and their secretary is not empowered to approve this, then this contract has not been approved by the Secretary of Justice as provided by law.
Mr. Secretary, as per documents you had submitted to this committee, the contract or joint venture agreement was entered into between Tadeco, represented by Antonio Florindo Sr., and the Bureau of Corrections, represented by Ramon J. Liwag, officer in charge, duly approved, Simeon A. Datumanong, Secretary. Do you confirm these documents on file with your office?
I have 1 minute, Mr. Chairman. Okay. So, 2003. So approved. Approved. Per information from our Chief State Counsel, it was approved by Secretary Datung Manong, then Secretary of Justice. So if that's the case, then it is approved by the Secretary of Justice.
And that the addendum to that contract was also approved by then Secretary Raul Gonzales.
From the Director General of BuCor, Attorney De Los Santos, who is now present, that's correct.
Okay. In that connection, Mr. Secretary, I heard you saying in your preliminary remarks that you are recommending to the President for the rescission of this contract. Why do you wait for the action of the President when the contract was entered into and by the agency attached to your office and duly approved by the Secretary? Isn't it that it is within your level to rescind the contract considering the adverse findings that your office have discovered once you conducted the investigation?
Your Honor, I am not really sure if the Department of Justice has the power and the authority to rescind a contract between BuCor and the Tadeco. Although the BuCor is a government agency with a separate personality from the Department of Justice, I believe it is only the Bureau of Corrections that could question this particular, the constitutionality or the validity of this particular contract, because BuCor is the contracting parties.
But
I recommended that the same be cancelled by the President, because that's the easier way. If there will be a case filed by BuCor against the Tadeco, it will take a very long time before it could be considered finally decided, Your Honors. So it is my recommendation that in order not to prolong this, we believe it's an illegal contract, the best and the fastest way is for the President to cancel this contract. Otherwise, the alternative would be for BuCor to file the appropriate action in court for the rescission or for the declaration of nullity of this particular contract.
that's all, Mr. Chair, for this humble representation. Thank you
Thank
very
you,
much, Mr.
Representative
Secretary.
Bominal. May I now recognize Representative Anthony Bravo?
Thank you, Mr. Chairman. Good morning to everyone. Our Secretary.
Good morning, Congressman Bravo.
Mr. Chairman, I just be clarified, how many hectares were covered under the joint venture agreement entered into by and between BuCor and Tadeco in 1969?
Originally, that's the beginning of it's 3,000 hectares, Your Honor.
So, in 1969, there were about 3,000 hectares covered
Actually,
in the joint agreement.
exactly 3,000 hectares.
Okay. So, when was the time that it reaches an area of 5,212.46 hectares?
There were several renewals, but it reached the current 5,308 hectares on May 21, 2003.
So, an additional of more than 2,000 hectares during the consolidation was added in 2003. Right.
That's correct, Your Honor. But before it reached 5,308, there were series of amendments or as to the number of hectares to be covered by the contract.
Thank you for that response, Mr. Secretary. Mr. Chairman, may I just get backtrack a little bit. When was the time or year that such particular land was declared to be a reserve land of for penal colony?
Honor, it was declared as a penal reservation and a government penal colony on October 7, 1931
So 1931.
by Governor General Dwight F. Davis under proclamation number 414.
And what was a significant provision in that particular proclamation that is related to the joint venture agreement between the BuCor and Tadeco?
At the time it was proclaimed, Your Honor, there was yet no NBP or BuCor-Tadeco contract, so we could not expect any relevant provision in when this was declared as a penal reservation in 1931.
So, Mr. Chairman, with that declaration, it classified the land as a reserve land. Am I correct with my understanding?
That's right, Your Honor. It was declared as penal reservation and a government penal colony.
So therefore, if it is a reserve land, it cannot be declared as alienable and disposable.
Well, it could if the president so declared it. In other words, before the president, and up to now, there is yet no declaration by any president that this parcel of land, originally 28,000 hectares, has been declared as alienable and disposable. So, as of the present, the character of this land is inalienable,
So
cannot be alienated.
from 1931, Mr. Chairman, up to present, clearly the classification of the land is inalienable.
That's correct, Your Honor.
So you are telling us a while ago that such land is covered by Commonwealth Act 1935.
141, the Public
141,
Land
I
Act,
mean, sorry.
Public Land Act, Your Honor.
Am I correct that Commonwealth Act 141 covers only alienable and disposable land?
The Public Land Act number 141 covers mostly inalienable public land act. In other words, those who have not been declared yet as alienable and disposable by the President.
May I go back to joint venture agreement and the term used lease contract? Are they the same?
Ano, may question ba? Your Honor, that's the point we are belaboring a while ago, that although this contract is denominated as joint venture agreement, we have concluded that this is more a lease agreement, not a joint venture agreement.
So it cannot be the same as the term used as joint venture agreement and lease agreement is different thing.
Yes, Your Honor.
And you are contemplating that the joint venture agreement entered into by and between BuCor and the Tadeco is not indeed a joint venture agreement, but rather a lease agreement.
That's what I was saying a while ago. It is akin to a lease. So more or less, it's a lease, not a joint venture agreement.
But in document that is being presented to this committee is a joint venture agreement that is entered into by and between the two parties.
Well, that is denominated as a joint venture agreement, but we know in law that what characterizes a document is the body of the document, not as to how it was denominated.
Mr. Chairman, how many penal colony do we have in this country?
We have 6, 7, including the NBP.
And since this is a subject for inquiry related to penal colony, are there any other penal colony similarly situated with Davao Penal Colony that has entered into agreement with private or corporation similar to Tadeco and Davao Penal Colony?
May I ask our Chief State Counsel if he knows? May I ask our DG Director General Benjamin de los Santos to specify the different colonies as well as if there's any similar agreements entered by the NBP with respect to other penal colonies?
Your Honors, Dapicol is peculiarly the only one with the same arrangement, Your Honor.
So it's only Tadeco that has
Tadeco, Your Honor.
Okay. Thank you for that answer. Now, may I go back to the 3,000 and 2,000? If the maximum allowed number of years is 50 years, will it not be that the 2,000 hectares, more than 2,000 hectares, that was consolidated, making it more than 5,000 in 2003, can still be extended to complete 50 years?
Don't believe so, Your Honor, because in the first place, the 3,000 is already illegal. So any addition or subtraction from 3,000 should be considered illegal also.
I'm asking that, Mr. Chairman, because I would like just to check that these areas has employed people. Am I correct?
That's correct, Your Honor.
And how many jobs were created under this economic activities in the area?
Nandyan eh. We have an average of 1,112 minimum security risk inmates who are working in the area.
So are there any other workers aside from the inmates being utilized in the area?
Well, I believe that the workers or the employees of Tadeco should be working there also. But aside from that, we are not aware of any other group of workers working there at.
So since there are workers involved in the area, how many think household or families that are benefited by the economic activities in the area?
Well, we could say that since there were 1,000 workers, then thousands of members of the families are also benefited. This is the reason why in our third recommendation, we would like the President to declare these areas as alienable and disposable in order that they could still utilize this. And even, as a matter of fact, Secretary Manny Piñol of the Department of Agriculture has approached me and wanted to have a similar ventures, joint ventures agreement with our penal colonies for the Department of Agriculture to plant rice and other crops in the area.
Aside from the rental that is being paid by Tadeco, Mr. Chairman, Mr. Secretary, do Tadeco pay taxes to the government?
I believe so, Your Honor, and the records will show. As a matter of fact,
do you have any figure? How much?
well, in the preliminary report we submitted, according to the comment of Tadeco itself, that they are paying taxes, and I believe that
the JV generated daw,
according to Tadeco, the JVA or this lease generated 295 billion in taxes and fees in 26 alone. I believe that there must be some error in this because it's so big. 295 billion.
I think that, Mr. Chairman,
it should be what?
Mr. Secretary, I think we need
It should be million.
We need to check whether or not the corporation is indeed compliant to the BIR.
So yes, Your Honor. So I think it's been corrected. There was an error really. It's not billion, 295 billion, but 295 million only.
So for the meantime, Mr. Chairman, that's all. Because I know that the good secretary will be having appointment.
Thank you,
Next,
Representative Bravo. The chair will now recognize Representative Winston Costello.
Thank you very much, Mr. Chairman. Mr. Secretary, we listened intently to your opinion with respect to the case at hand. And one of the findings here is the finding some irregularities, no? And this representation now would like to know the direction of your office. Will you be filing a case, or will you just, or you will be submitting the recommendation and opinion to the office of the Ombudsman, or do both things, Mr. Secretary?
Your Honor, the course of action which you are going to take is indicated in our recommendation, and we could furnish, considering that we know that a case has already been filed with the Ombudsman in connection with this, we could furnish the Office of the Ombudsman our opinion for whatever it may be worth. But with respect to the filing of the case against or in connection with this, it is my opinion that it should be BuCor who should file, since it's the party in the case. If I believe that the Department of Justice has no personality to file this, but of course, under the law, we could render an opinion. So the most we could do is to direct the being an attached agency to direct the BuCor to file the appropriate case for cancellation or for declaration of nullity of this particular contract.
But, sir, under the bureaucratic structure, the DOJ is the mother office of the Bureau of Corrections.
That's correct, Your Honor. But since although the Bureau of Corrections as a separate is an attached agency, it is a separate personality. And I believe that under the present circumstances, it should be BuCor who should, if it like so, who should file the appropriate action to invalidate this contract.
Thank you very much, Mr. Chairman.
Thank you, Representative Castello. The chair will now recognize Representative Doy Liachon.
Thank you, Mr. Chair. Good morning, colleagues. And good morning, Mr. Secretary.
Good morning, Mr. Congressman.
I just have a few questions related to this inquiry. Of course, we have so many concerns regarding or whatever legislation that may be crafted out of this inquiry, including the treatment of public lands, on how public officials should act with respect to his domain. But then I have few questions relative to this one, especially in connection with the recommendations that you have uttered. First and foremost, Mr. Secretary, would you agree that even though it's a separate entity, primarily the functions of the BuCor chief or the one in charge of the Davao Penal Colony would be definitely administrative in nature?
Yeah, partly correct, Mr. Congressman, Your Honor.
And yes, considering that it's part of his job to administer the entire property, so with the management with respect to relations of that property with respect to other persons, we know for a fact, in fact, the subject inquiry that they drafted a contract. Would you agree with me, Mr. Secretary, that considering the admittedly huge vast of lands and considering further the gargantuan amount of money involved, would you think that, well, based on your recommendations or with the wordings in the resolution filed no less than by the Speaker, would you agree with me that the BuCor chief during the time who signed the contract, so with the other contracting party, just turn his blind eye or turn into blind eye, not taking into consideration the amount of money, so with the wide vast of land, that he acted manifest partiality in favor of that contracting party? Or if not through manifest partiality, there was definitely grossly inexcusable negligence on the part of the contracting party, especially on the part of the government or the BuCor chief during that time?
Your Honor, it's very possible, considering that our initial study is that there are so many provisions here, as we have indicated, in connection with the amount of rental. There is no public bidding. That there must be that the contract, the execution of the contract may be attended with gross negligence, or some provisions of it are grossly disadvantageous to the government, which could be violative of the Anti-Graft and Corrupt Practices Act 1019.
Okay, just to cut it short, you would like to agree with me, Mr. Secretary, that there was manifest partiality on the part of the BuCor chief, resulting to the injury on the part of the government, and considering that per analogy or recommendation by the Solgen, that there was failure on the part of the contracting parties to observe the rules regarding competitive bidding, would you agree with me that there was unwarranted benefit given to the private party in the contract or preference by virtue of such inexcusable negligence, Mr. Secretary?
On its face, there could be, but of course, to prove this, we must conduct some more or deeper investigation on the matter.
But
Because
give-
this happened many, many years ago.
Yeah, but given the requisites that we just discussed about this one, there was administrative function, there was inexcusable negligence, and you seemingly agree with me. There was injury on the part of the government, considering the loss, and there was an unwarranted benefit. Would you agree with me, Mr. Secretary, that those circumstances definitely fall within the ambit of the Republic Act 3019?
That's right, Your Honor.
If that is correct, Mr. Secretary, would you agree with me, or would you amend your recommendations, considering that we have heard that only part of those recommendations will just be to file revocation or civil aspect of the case? Would you agree now that apart from that, there would be inclusion as to the filing of the appropriate criminal action against the parties concerned?
I will, in that particular instance, Your Honor, I'm going to recommendation that if the evidence says so, then to file the appropriate criminal cases under the law, specifically violation of Republic Act number 3019.
Thank you, Mr. Secretary. And lastly, in connection with that, considering that you are now agreeing that more or less there was culpability or criminal liability on the part of parties concerned, in fact, the DOJ would have definitely the jurisdiction to initiate investigation in order to ferret the truth as regards the truth of the matter, as regards the matters contained therein, especially the criminal aspect of the case, Mr. Secretary.
Yes, Your Honor. Under the law, the DOJ has concurrent jurisdiction with the Ombudsman to conduct the preliminary investigation of this case. However, since our jurisdiction is for the conduct of preliminary investigation, in that it is the Ombudsman who has the primary jurisdiction over this case against public officials, then in the event that this is filed before the DOJ for preliminary investigation, and that in case we find probable cause, we are still mandated to forward our findings to the Ombudsman for its own assessment.
Thank you, Mr. Secretary. Mr. Secretary, we'll just be expecting and awaiting the full-blown recommendations to be submitted by the Department of Justice. Mr. Secretary, salamat po. Mr. Chairman, thank you.
Thank you, Your Honor.
Thank you, Representative Liachon. May we acknowledge the presence of Deputy Majority Leader Victoria Noel, Representative Ching Veloso, Vice Chairman of Committee on Justice, Representative Franz Castro. The Chair will now recognize the next interpellator, Deputy Speaker Gwen Garcia.
Thank you, Mr. Chair. The outset, may I just state that there seems to be two issues here. First is whether or not the joint venture agreement is indeed valid or void, and the second is the provisions that are contained in the joint venture agreement entered into, the consolidated joint venture agreement entered into between Tadeco and BuCor. Now, as to the provisions, as regards the effective rate by which 5,000 plus hectares are being benefited from by the BuCor, which if you would put in all of the other benefits, from 5,000 per hectare, this would go up to about 8,000 per hectare, including land development and other benefits given. Perhaps that really bears restudy, including the minuscule profit sharing that is given to BuCor, considering the price per case of bananas that the foreign market is now giving, which, if I'm not mistaken, is now at $12 per case, and BuCor is given less than a peso per case. But if I may just go back to the consolidated joint venture agreement, which is being assailed by both the Office of the Solicitor General and the Department of Justice Undersecretary's opinion. May I ask the good secretary, because he has opened this up himself earlier, when upon earlier questioning, first of all, he pointed out Section 2 of the 1987 Constitution. Just to lay the premise, I also heard it from the good secretary that the area in question is considered inalienable because there has been no declaration by the President that this, in fact, is alienable and disposable.
That is correct, Your Honor.
That is by virtue of the proclamation signed by then Governor General Dwight Davis, which identified a certain number of hectares as belonging to the penal colonies. Now, Secretary, there have been opinions set forth that the 5,000 hectares actually should be considered a lease rather than a joint venture. And because it is considered a lease, therefore should be subject to Section 3 of the 1987 Constitution, which limits the lease to not exceed 1,000 hectares in area.
That's correct, Your Honor.
If I may read, lands of public domain are classified into agricultural, forest, or timber, mineral lands, and national parks. Agricultural lands of the public domain may further be classified by law according to the uses to which they may be devoted. Alienable lands of the public domain shall be limited to agricultural lands. Private corporations or associations may not hold such alienable lands of the public domain except by lease for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares in area. And so it is very clear that alienable lands of the public domain may not be leased in excess of 1,000 hectares. But it is that right, Mr. Secretary?
That's correct, Your Honor.
But it is also very clear that alienable lands of the public domain shall be limited to agricultural lands. Is that right, Mr. Secretary?
Yes, Your Honor.
Now, Section 2, as you had previously read, states that all lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests, or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. This statement, in fact, should include what has previously been identified by the good secretary as inalienable by virtue of Proclamation 414. Is that right, Mr. Secretary?
That's correct, Your Honor.
And that therefore, the exploration, development, and utilization of natural resources shall be under the full control and supervision of the state.
That's correct, Your Honor.
And if I may read further, the state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or corporations or associations, at least 60% of whose capital is owned by such citizens.
That's correct, Your Honor.
If I may ask the good secretary, having laid the premises of both Sections 3 and Section 2 of Article 12 of the 1987 Constitution, would you say then that the joint venture entered into between Tadeco and BuCor, which was renewed in 2004, for another 25 years, would this joint venture fall into what is contemplated in Section 2 of the Constitution?
Your Honor, that's precisely why I was asking these honorable committees to give the Department of Justice more time to study this, because this is a particular portion that was not looked into or was overlooked by our prior opinion sent to these honorable committees by our Secretary Mikate. We would like to study this further, because this would be, we have to balance this with the Public Land Act, where it seems to have some conflict. However, we would like to study further as to how we are going to harmonize this Section 2 of Article 12 with the Public Land Act, Commonwealth Act number 141. Because if the 1987 Constitution is inconsistent with the Public Land Act, then it definitely would have amended or supersede this provision of the Public Land Act. So this is that particular portion that we would like to have some more time for study by the Department of Justice. This is precisely the reason why I believe that the department has overlooked this Section 2 of Article 12.
Thank you, Mr. Secretary. Further, as I had earlier mentioned, the consolidated JVA was renewed for another 25 years, commencing on the 26th of September 2004. The 50-year limitation of joint venture agreements, it has been referred to assailing the supposed 60-year or the period under which this consolidated joint venture agreement should operate as having gone beyond what is allowed under the Constitution. But since this joint venture agreement was renewed 26th of September 2004, would the prevailing 1987 Constitution be then the law by which the joint venture agreement must be scrutinized? Mr. Secretary.
That's correct, Your Honor. So even assuming that all other provisions of this contract are legal, then the term of the contract, which is beyond the allowable limit under the Constitution of 50 years, it could not go beyond 50 years, which is or the year 2019.
Then when would be the date of reckoning for the actual count to begin, Mr. Secretary? Because I am confused. There are several joint venture agreements, and yet in 1979, a consolidated joint venture agreement was entered into for a period of 25 years, and then again, in May 21st of 2003, this consolidated joint venture agreement was renewed for another 25 years. By this presentation, would the 50-year limitation be followed by this consolidated joint venture agreement, or should we start reckoning from the first joint venture agreement entered into in 1969?
It should be reckoned as of 1969. And so if this was renewed on September 26, 2004, then that it will end on September 25, 2019.
Mr. Secretary, if I am to be, if I hope I am wrong, but what I could understand was that there were several joint venture agreements entered into during different periods pertaining to different parcels of land. And hence the need for a consolidated joint venture agreement which eventually covered the total of 5,000, because I think the first joint venture agreement referred only to a certain 3,000 hectares, if I'm not mistaken, and then there was an additional 750 and an additional number of hectares that were added. And so the 1979 consolidated joint venture agreement would now refer to the 5,300 plus hectares that Tadeco eventually entered into this joint venture with BuCor. So would it? It is the position of the Secretary that reckoning should start from 1969, not the 1975 consolidated joint venture agreement entered into by both parties.
Yes, Your Honor. Actually, our opinion, the DOJ official opinion, would be 1969. But the panel whom I created to study this in the first place was of the opinion that it should be reckoned as of 1975. 1969.
No, it's 19... The consolidated joint venture agreement was entered into on the 26th of September 1979.
Tapos, there were several extensions. So therefore, in 25,
Deputy Speaker, can you please wrap up the interpellation? 5 minutes is already up.
Yes, Mr. Chair. At any rate, if there is an inconsistency of opinions, my question continues, when the date of reckoning should start. And in the end, Mr. Chairman, I reiterate the fact that there are two issues involved here. The, shall we say, provisions of the joint venture agreement which could certainly be improved upon, especially in the amount by which each hectare stands to gain from 5,000 more or less per hectare return, or including all other benefits, this goes up to about 8,000 vis-a-vis prevailing prices, and whether or not the joint venture agreement is in fact valid, or should it be considered a lease with the seeming conflict between Commonwealth Act 141 and the 1987 Constitution, particularly Sections 2 and 3 of Article 12 on national economy and patrimony. There is a third issue too, and that is, and I reiterate the statement of the Chair of the Committee on Justice, that we must look into greater transparency and accountability of whatever government land, particularly penal colonies, are earning out of certain agreements that they have entered into. That is all, Mr. Chair. Thank you.
Thank you, Deputy Speaker Gwen Garcia. May we acknowledge the presence of Representative Ruel Peter Gonzaga, Deputy Majority Leader Ann Hofer, Representative Ron Salo, Representative Strike Revilla, Deputy Majority Leader Victoria Noel, Representative Ching Veloso, Representative Franz Castro. The Chair will now recognize Representative Harry Roque.
Thank you, Mr. Chair. Well, my first question to Secretary Aguirre is there was a mention repeatedly of the 87 Constitution, and but the contracts that we have before us were executed prior to 87 Constitution. No? So my first question is there any relevant textual differences relative to public land between 1935, 1973, and the 87 Constitution, or do they provide for the same thing? That is, that unless declared as being agricultural, that lands remain under the public domain and may not be the subject of any form of private encumbrance.
Thank you, Your Honor. Actually, I've read 1973, 1935, and 1987 provisions in connection with the utilization of natural resources. They have different provisions, Your Honor. That's why I would like to further study them and see what could be any conflict with the Public Land Act of Commonwealth Act 141.
Now, the good secretary said he wants to study it. What particular issue do you want to study? What is the textual provision of the 73 Constitution, which apparently is a constitution in force when these two agreements were entered into?
The 1987 is also coming into play. I respectfully want to study whether there could be some amendment, or whether there could be some inconsistencies between the 1973 and the 1987 Constitution in relation to Commonwealth Act number 141, or the Public Land Act.
And what is that inconsistency, Mr. Secretary?
Particularly, Your Honor, read. It is our initial opinion that since this is an inalienable public land, then it couldn't be the subject to the commerce of man. But under 1987 Constitution, it is stated that the exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreement with Filipino citizens or corporation, etc. So it seems that under the Section 2 of Article 12, parang pinapayagan ang that this inalienable lands could be subject of agreements.
Now, forgive my ignorance, but if these lands are inalienable under any constitution, my question is, what basis did BuCor have in entering into these agreements in the first place? If they are inalienable in the first place, is there a provision in the Constitution or any existing law that would provide an exception for a government entity such as BuCor to enter into an agreement in contravention with the textual provision of the Constitution?
Actually, I don't feel comfortable with equating alienation with disposition. So I believe that even though the land is still inalienable, I believe that under the 1987 Constitution and 1970 Constitution, it could be a subject of contract.
So, in effect, what you're telling us, Mr. Secretary, is because it is now being examined in the context of the 87 Constitution, that contracts such as this should have been in the form enumerated in the Constitution, co-production, FTAA, and what have you, and that the current form, whether be it you call it a joint venture or a lease agreement, does not conform with the 87 Constitution. Is this correct?
Yun po ang gusto kong pag-aralan pa.
Now, I know you undertook that you will study the matter, but you have also issued an opinion that this contract is illegal, no? Legally infirmed. No? So can you brief this committee on what steps both the DOJ and the OSG will undertake in relation to this particular contract after your opinion?
Your Honor, although we have concluded that this contract could be declared as illegal or could be nullified, it is not solely on the basis of under Section 2 or Republic Act, Commonwealth Act number 141, but in connection with other provisions that are not legal. As for example, there was no public bidding, and the area is 5 times more than allowed under the Constitution, and the period is much longer than that allowed in the Constitution, and some of the provisions, terms on the contract is very disadvantageous to the government. So there are 4 areas where this matter could be declared as unconstitutional or invalid, and in addition to this apparent conflict between Commonwealth Act 141 and the 1987 and 1973 Constitution.
Pero ano pong course of action nyo? Pupunta ba ho kayo sa hukuman? Ano ba hong proper action na dapat i-institute kapag may ganitong, pursuant to your opinion, is an illegal disposition of the land of the public domain?
Actually, which we received from Speaker Alvarez, they are asking us to declare more or less the contract as illegal. I believe that we could not do it. The Department of Justice, the Secretary of Justice could not do it, and I believe that it is the President who could declare this as illegal and cancel the contract immediately. However, if the President would not act on this, then the next we are going to recommend or to make a recommendation to the BuCor that they should institute the appropriate action for the declaration of nullity of this particular contract. Since BuCor is the party with Tadeco in the execution of this contract.
Lastly, Mr. Secretary, because this is in aid of legislation, alam niyo po, napakatanda na niyang Public Land Act na yan, Commonwealth Act pa yan, no? And obviously, this is an opportune time to review this ancient law, no? Now, to preclude what your earlier conclusion that contracts such as this is illegal, can you recommend like a very important amendment that Congress should enact, no, to prevent any similar occurrence from happening in the future?
Yes, Your Honor. In the further study which we are going to do, then we'll take that into consideration and find some very good recommendation so that this could be avoided in the future. And of course, so that if necessary, the particular or the specific amendments to the Public Land Act could be made.
Sabi ko last, no, pero if I have one more minute, no, sa 87 Constitution po nakasulat yung mga FTAAs pwedeng pasukin, pwedeng magkaroon ng co-exploration even with foreign entities on FTAA pursuant to Labugal, provided signed by the President and submitted for Congress for review. Do you recommend that disposition of lands of the public domain should be subjected to the same conditions, no? A contract personally signed by the President, which should be reviewed by policymakers because this is a new policy, no? Allowing private entities to use lands of the public domain, no? Which really contravenes the concept of land of the public domain. Do you recommend that?
Actually, what I could recommend is that it should be Congress who should be enacting the law, the enabling law, giving the President such power in the utilization of our natural resources. But it should not be made that the action of the President should be approved or submitted for disposition by Congress.
Thank you, Mr. Secretary.
May I just interject on that point? I went over some of the contracts and or JVAs. I don't know. There are many documents submitted to us by Department of Justice, and the principal signatories are Director of Prison, with the approval of Department of Justice. So please take a second look at that matter of raising or elevating the matter to the President to revoke whatever agreements there are, because that may be going beyond the ambit of the contracts executed between the parties. So pakitingnan lang po 'yon para hindi ho tayo lumayo dun sa ating inquiry.
Yes, Mr. Chairman, we will do that.
The chair will now recognize Representative Casilaw.
Thank you, Mr. Chairman. Mr. Secretary, ang subject po ng inyong investigasyon, which led to the findings and recommendation, only covers 5,308 hectares under the GVA. But may I ask for officials or under your office, ilan na ba talaga ang ng Tadeco na hindi o labas doon sa 5,380 hektarya ng GVA. This representation firmly believes, together with the colleagues in Makabayan, na maliban doon sa posibleng rekomendasyon ninyo sa nullification or pag-declare na void yung kontrata ng GVA, maaari pa po ba nating malaman na yung 5,308 ay meron pa pong mahigit 6,000 na labas doon sa kontrata? May I ask the official statement of BuCor, ilang hektarya na po ba talaga ang nananatili sa reserbasyon ng Davao Penal Colony?
With the permission of the Chair, historically, Your Honor, from the original 28,816 hectares, as of today, what is left is 103.38 hectares.
Mula noong 1930 na nagkaroon ng mga napakaraming proklamasyon at kasama dito yung mga pinasok ng mga joint venture arrangements or agreement, 100 na lang ang natira out of the 28,000.
Opo, 103 po. 103.3889.
Yung iba po ba ay nailagay sa mga usapin ng land reform distribution?
Opo, I take that question as an opportune time to raise the fact that since the inception of Proclamation number 414 in October of 1931, from the original 28,816 hectares, several proclamations followed, awarding portions of the original area to different, for different reasons, to include settlement areas for those who are occupying various portions of the land. In fact, in 2012, there was a strong position from the Department of Agrarian Reforms and DNR in reviewing the JVA, Your Honors.
Yes, Mr. Secretary, Sa kondukta po ba ng inyong investigasyon at bago po lumabas itong inyong findings and recommendation, have you or the investigation team conducted an actual aerial visitation, actual interview, actual mapping prior to determining in the documents that the GVA is only covering 5,308 hectares?
To be frank, Your Honor, we did not conduct any investigation, any on-site inspection, or any survey of the area. So I believe that if we really wanted to get the specific areas being utilized by Tadeco in this relevant to this contract, then no less than an actual survey should be made, because this specific problem or only came out during the administration of during the present administration only about several weeks ago, Your Honor.
Mr. Secretary, in the 16th Congress, a colleague of mine from Makabayan also filed a similar resolution to conduct a survey and mapping. And lumabas po doon na meron pa pong mahigit 6,000 hektarya under the supervision of DAPICOL na labas doon sa 5,308 hectares na nakapaloob po sa GVA. At kaya nga ang kinatawang ito kasama ng Makabayan Block ay naghain ng resolution para upon the findings of any competent body such as the Department of Justice, the Office of the Solicitor General, nullifying or recommending to nullify and declare void of the GVA entered by BuCor and Tadeco, our firm recommendation is for this hectares, for these thousands of hectares of land be transferred to the Department of Agrarian Reform and mapapaloob po sa proseso ng pagbibigay nito sa reformang agraryo. We have here, Mr. Secretary, a petition to your office received by your office October 21, 2016 by the Dr. Bay. These are agrarian reform beneficiaries. And we have a copy of more than 20 agrarian reform beneficiaries associations struggling in the area of DAPICOL since 1960s, cultivating the lands, the vast tract of banana plantations, but they were only considered as they hold the title. Yung iba po may mga titulo, yung iba po hanggang sa kasalukuyan mahigit 30 taon na po ay nakikibaka para maibigay sa kanila. Dahil yung sinasabi niyo po kanina, beyond the commerce of men and upon any law na magkaroon ng batas para ito ay mapamahagi, aside from the declaration of the President that this is alienable and disposable, meron na pong batas noon pa man. PD 27, Republic Act 6657, Republic Act 9700, na itong mga lupang ito, agricultural in nature, pero nakapaloob supposedly sa mga onerous and anomalous contracts as you have found in your recommendation upon your investigation, ay sana po mailagay na sa proper perspective na ang dapat makinabang sa mga lupang ito ay ang ating mamamayan, lalo pa ang ating mga magsasaka at mga agrarian reform beneficiary. Now, Mr. Secretary, may I ask for your categorical answer, would you recommend part of your recommendation on your findings that these lands, the 5,308 and the more than 6,700 hectares under the supervision of DAPICOL, BuCor, the 5,308 napaloob sa kontrata, pwede po ba nating alamin din yung 6,000 na nasa supervision ng DAPICOL na walang anumang kontrata pero nasa supervision ngayon ng Tadeco at ng DAPICOL, ay maitransfer ito at maipamahagi bunga ng ating batas sa reformang agraryo. Would you consider that as part of your recommendation doon sa ipinalabas ninyong dokumento?
Doon po sa sinabi ninyo, I'm going to consider na magkaroon ng survey or mapping, yung sinasabi ninyo, kung talagang aside from the 5,308 hectares, ay meron pa rin ino-occupy ang Tadeco dun sa area na yan. Ngayon, with respect to them being alienated or disposed of because of the pursuant to agrarian reform program of the government, I believe that first things first, the area must first be declared as alienable and disposable by the President, and I believe that in the event that this proclamation is issued by the President, then the peasants or those stealing the land must make the proper recommendation with the President that the same be declared as to be alienated pursuant to the land reform program of the government. So dapat muna siguro magkaroon ng declaration. Otherwise, any occupation would be illegal.
It is true, Mr. Secretary. But again, we have all the reasons to believe na kahit na ito po ay sinabi na po ninyo sa inyong findings ay unconstitutional, doon po sa usapin ng disadvantageous ba ito, ang ating mga agrarian reform beneficiaries na mismo nakapagsasabi, bawat hektarya po nito ay hindi lamang nagkakalaga ng 2 o 4 na milyon. And in fact, there are a lot of other contracts there amounting to 14 to 16 million per hectare. Yung appraisal ng lupa. Ngayon, ang binabanggit dito, napakaliit at napakalugi ang ating gobyerno as found out in your investigation. Yun pong sinasabi nating maideklar, dahil po ito ay public land, ito po ay nasa reservation, isegregate natin yung use for sa inmate, sa DAPICOL, pero dahil yung pong mga lupang napakalawak ay ginagamit na po for agricultural use, is it not wise that we have already existing laws on the land reform programs na hindi na po, kailangan na lang po na magdeklara ng Department of Agrarian Reform or the DENR na ito po ay pwede na pong ma-issuehan ng emancipation patent or certificate of land ownership award doon po sa mga matagal na pong nagpetisyon. And we have already, as I have mentioned, almost 20 agrarian reform beneficiaries na matagal na pong nagpetisyon nito sa loob po ng mula pa noong 1960 hanggang sa kasalukuyan. Is it not wise na totoo, kailangan nating hintayin yung proklamasyon ng ating Pangulo, pero meron na pong mga batas. At sa kapangyarihan ng DNR na maaari siyang mag-issue o sa kapangyarihan ng Department of Agrarian Reform na maaari niyang i-cover ito sa pamamagitan lamang ng deed of transfer from BuCor to the other government agency.
Wala po kaming objection dyan, Your Honor. As a matter of fact, it is high time and very propitious that this be done, considering that the Secretary of Department of Agrarian Reforms belongs to the left and very supportive of your advocacy. Kaya I think it's very timely that you should pursue that, and we are going to support it. We have no objection if it will be given to your people.
Salamat po, Ginoong Kalihim. Mr. Chair, just a brief
your 5 minutes
manifestation.
already consumed.
Yes.
You please wind up your interpellation.
A very brief manifestation. We have here who traveled from Tagum and Panabo, Davao del Norte, officers of the Daktar assisted by their legal counsel, Attorney Jaime Jun Lopos. If they could be given a very brief manifestation or statement, because again, as I have mentioned, they have already a petition in the Department of Justice, and hopefully the good secretary will act timely and urgently, because napag-uusapan na po natin ang mga isyong ito, at sa usapin sa kontrata ay nandito din ang kabahagi. Mabigyan po sana sila ng kahit konting panahon na mapakinggan, dahil nga po napakahalaga na sa mga usaping ito, hindi lang po lugi ang gobyerno, hindi lang po sa usapin na nagkaroon ba ng kailangan na malaking lugi, pero at the end of the day, who will benefit on the findings and recommendations that will be released ay dapat yung ating mga magsasaka at mga agrarian reform beneficiaries. Maraming salamat, Mr. Chair.
Thank you, Representative Casilo. Are you giving any statement, Secretary? Wala na po.
Wala na po. Thank you.
Thank you, Mr. Secretary, for your time. We will now hear is any statement from any official from Tadeco.
Thank you, sir. My name is Alex Valoria. I am the President and CEO of Tadeco. May I go into my statement, sir? Thank you, sir, for this opportunity. Your Honors, distinguished members of the House Committee on Good Government and Accountability and the Committee on Justice, ladies and gentlemen, good morning. Allow me first to give a little background on Tadeco. Our founder, Mr. Antonio Florendo, started Tadeco in 1949 to produce abaca hemp. That land was adjacent to the Davao Penal Colony, or Dapicol for short, and everything there was mostly a swamp in the hinterlands of Davao. At that time, travel to that area needed a truck, then a carabao, and then a bangka. However, Don Antonio, being an engineer, was confident that he could find a way to drain that water and make the land productive. In 1956, the neighbors, Tadeco and Dapicol, under the Bureau of Corrections, or BuCor, or at that time the Bureau of Prisons, began their first joint venture to produce hemp and split the production 60-40. The partnership was very successful, but the challenge of nylon rope in the 1960s proved too much for Philippine hemp, and thus prompted the partnership to transition to banana production for export. In 1970, the Senate Blue Ribbon Committee reviewed the contracts between Tadeco and BuCor, and after a thorough investigation, the committee found that the contracts were indeed valid and above board. Notable were the comments of Senator Benigno Ninoy Aquino, Jr., with regard to the confirmation that the rates at that time benefiting the BuCor were extremely good and beyond competitive. Likewise notable was the report of then Secretary of Justice Juan Ponce Enrile, clearly stating that the contract was indeed a joint venture relationship between the parties. There were subsequent addenda that added more Dapicol land to the joint venture agreement as its success became more and more apparent. Due to the complications of multiple documents governing the partnership, the partners deemed it best to novate all the documents and come up with one single joint venture agreement in 1979. During the time of former President Cory Aquino, the JVA between Tadeco and BuCor was again reviewed. The Department of Justice created a team by then Undersecretary Silvestre H. Bello to undertake this task. The JVA was once again found to be beneficial to government and to the success of the rehabilitation program. The success of the rehabilitation program was again recognized. As a result of this review was the signing of a new consolidated joint venture agreement, or CJVA, between Tadeco and BuCor in 1989 that contained new and improved terms for BuCor. In fact, on July 11, 1989, President Cory Aquino herself authorized the BuCor to execute this very CJVA. This CJVA confirmed that the start of the joint venture agreement is indeed 1979 contract. The subsequent renewal of the JVA in 2004 was also reviewed by then Secretary of Justice Raul Gonzalez and was likewise found to be beneficial to the mandate of BuCor. In 2012, the Committee on Agrarian Reform of the House of Representatives also examined the JVA and found out that it was in fact beneficial to the government and to the community. In fact, the Department of Agrarian Reform uses Tadeco as its showcase of success of its agrarian reform program. The agrarian reform cooperatives in Tadeco have today assets in the hundreds of millions of pesos, whereas we understand the agrarian reform cooperatives in other banana farms have quite the opposite. Debt levels going up even to the billions of pesos. Today, Tadeco is a very successful banana production and export operation. The land owned by the now Davao Prison and Penal Farm, or DPPF, that is committed to the joint venture between Tadeco and BuCor, is indeed 5,308.36 gross hectares, of which about 4,500 is the net planted area. And may I say, sir, the land has been subjected to multiple surveys in the past, and that's been confirmed that that is indeed the area. Tadeco has 12,000 employees, inclusive, more than 12,000 employees, inclusive of a rolling average today, a current average of 800 inmates that are enrolled in DPPF's rehabilitation program. Last year, in 2016, Tadeco paid out to its workers 2.8 billion pesos in wages, benefits, and incentives. A principal mandate of the Bureau of Corrections is the rehabilitation of prisoners, and the law states, quote, all BuCor lands shall be used for inmate security, reformation programs, and as a means to promote sustainability, both for income and non-income generating programs, end of quote. This is precisely what the BuCor has successfully achieved in DPPF. The core purpose of the JVA between BuCor and Tadeco is the rehabilitation of the inmates of DPPF, giving them agricultural and industrial training plus gainful employment, thereby providing them with the skills that will enable them to eventually integrate back into society as productive and responsible citizens. The inmates are able to earn money for their personal expenses for their families. The JVA is also a source of revenue for the DPPF for its various administrative and other needs. We have submitted videos, in fact we're showing one PowerPoint now, of testimonies of inmates to this effect with our position paper, Your Honor. We can elaborate lengthily on the role that Tadeco played in the last 6 decades in the socio-economic development of Mindanao, but the JVA is the subject matter today. And there is overwhelming data and proof of the success of the rehabilitation or reformation program. We estimate that about 5,000 ex-inmates have been absorbed by the banana industry itself when they were finally released from incarceration. Their training and discipline that they learned in DPF and Tadeco were highly valued by the companies they joined. In Tadeco alone, we currently have 104 ex-inmates, and the ones with the highest positions are that of executive driver and foreman. The JVA has been so successful that the BuCor, DOJ, and this is on record, have actually asked Tadeco to replicate this same program in the Iwahig Penal Colony in Palawan. We have in fact sent at least 2 teams of agriculturists to Iwahig to look for suitable land. The JVA, Tadeco, and our partner, the BuCor, have been subject to many reviews in the past. Every time there is a new administration or new DOJ secretary or new director at the BuCor, a review or probe is triggered. The various contracts between Tadeco and BuCor have been reviewed and approved by no less than 6 secretaries of justice, namely Juan Ponce Enrile, Vicente Abad Santos, Ricardo Puno, Catalino Macaraig, Cedfrey Ordonez, Simeon Datumanong, and Raul Gonzalez. It has also passed through 14 secretaries of justice who upheld its validity. A few of them are Franklin Drilon, Teofisto Gingona, Silvestre Bello, Neptali Gonzalez, and Ricardo Puno. And so here we are again, facing another probe that honestly caught me by surprise. I thought that this would be the one administration where we would not have to undergo another probe. Through his filing of House Bill number 867, Speaker Alvarez disparages the JVA and subsequently seconded by Solicitor General Jose Quilida in a press statement. Allow me, sir, to take up the Speaker's allegations one by one. First, the Speaker alleges that the JVA is grossly disadvantageous to the government. He points out that the BuCor is paid only 26,541,809 pesos per year, whereas prevailing lease rates in the area are at 25,000 pesos per hectare already. The Speaker thereby calculates that the government is prejudiced by 106,167,000 pesos. Our answer: last year in 2016, Tadeco actually paid the BuCor a total of 142,719,662 pesos. This is in the records and receipted by BuCor, and this equates to 26,900 pesos. We emphasize that the Tadeco paid to BuCor not only the guaranteed annual production and profit share, but also the inmates' farm training support, the stipend and support program, the training subsidy. The financial benefits paid by Tadeco from 2004 to 2016 amounts to 1,620,549,230 pesos. But the JVA is not only about money, Your Honor. The more important aspect to it is its core rehabilitation of the inmates that has been a proven success. The benefits to thousands of ex-inmates, their spouses, and their children, and finally to the communities they eventually settled into are immeasurable. Aside from the inmates, the banana operations from under the JVA create 30,000 jobs in direct, indirect, and ancillary roles. This translates to the secure livelihood and future of at least 181,000 Filipinos. The JVA is also responsible for 438,179,000 pesos paid in taxes and fees to the Philippine government in 2016 alone. That's 438 million. I challenge you to find an agricultural operation that provides these levels of benefits to our country. Number two, we read in the press that the Solicitor General issued a statement that the JVA violates the Public Land Act. The article has the Solicitor General saying, and I quote, "Under the Public Land Act, agricultural lands such as the Davao Penal Colony may be disposed of only through homestead of imperfect title." It should be noted that the BuCor and Tadeco entered into a joint venture. Clearly, a joint venture is not one of the modes by which agricultural public lands may be disposed. End of quote. Our answer, Your Honor: the provision that the Solicitor General refers to does not apply to the lands under the BuCor. The provision he stated refers to alienable and disposable lands in the public domain. The land of the BuCor is a government reservation and therefore is inalienable public land. As such, it cannot be subject of occupation, entry, sale, lease, or other disposition, and indeed there is no disposition of the land from the BuCor, as the agreement between BuCor and Tadeco is a joint venture. The Speaker and the Solicitor General also had described the JVA as a lease. It cannot, our answer, Your Honor, is that it cannot be a lease, as the principal objective of the JVA is the rehabilitation of the inmates of DPPF. The other provisions in the JVA are pertinent to this principal objective and its success. The subject matter of the JVA is part of a government reservation, hence it is inalienable land of the public domain. Such being the case, it cannot be a proper subject of lease agreement under Section 3, Article 7 of the 1987 Philippine Constitution. And the Solicitor General also stated himself that the agreement is in fact a joint venture. As mentioned earlier, the statement of then Secretary of Justice Juan Ponce Enrile back in 1970 is noteworthy. In Secretary Enrile's memorandum to the Senate Blue Ribbon Committee dated June 29, 1970, he summarizes as follows, quote, "We are firmly of the belief that the Bureau of Prisons Tadeco contract established a joint venture between the parties, aware as we are that the law prohibits the Bureau of Prisons from leasing any portion of the Davao Penal Colony, and that even if a lease could be entered into, such a contract would not bring any direct benefits to the Bureau because the rental to be derived therefrom would accrue to the National Treasury, not to the Bureau of Prisons, which was sorely in need of additional income to improve the lot of its 21,000 wards. We would not have approved the Bureau of Prisons Tadeco contract if it did not clearly create a joint venture relationship between the parties." End of Enrile's quote. Number 4, the Speaker questions the lease of 25 years, quote, instead of the reported prevailing practice of leasing with a term of 10 years, end of quote. Our answer, first of all, if it is not a lease but a joint venture, but for discussion's sake, we say that there is no such thing as a prevailing practice in land leases. In fact, there are some land leases that go up to 75 years. Number 5, the Speaker maintains that the FOB price of bananas is $12 a box. Our answer, Your Honor, is that how we wish that were true. Unfortunately, it is not the truth. Otherwise, all the independent growers would be driving Mercedes-Benzes instead of being in the dire straits they currently find themselves in. The spot prices indeed for China, for the China market, do swing wildly, reaching $9 per box for some weeks or month, but for the greater part of the year is rock bottom. Tadeco has 12,000 employees and their families to take care of. Thus, we must take a longer view and more stable approach, careful not to subject ourselves to a feast or famine type of market. That would be a recipe for commercial disaster, Your Honor. And finally, the Speaker raises the allegations that the workers are ill-treated and exploited. We answer that this is the most hurting of all the allegations. It is well known that Tadeco is one of the best employers in the agricultural sector. Of course, a person can always be found who is willing to be convinced to speak badly about a company or person, and indeed, we were made aware that there have been some operatives moving around our nearby communities looking for such persons. I sincerely ask the good members of the Joint Committee to be wary of those persons, and please let the facts speak for themselves. Tadeco has received multiple awards from various government agencies evidencing a motivated and well cared for labor force. Among other awards and citations, Tadeco has received the National Citation by the Philippine League of Labor Management Corporation Practitioners, Inc., PhilAmCop, in coordination with the National and Mediation Board, the NCMB, for its outstanding labor management cooperation for industrial peace. Tadeco was the first banana company to obtain Global GAP, which is Global Good Agricultural Practices certification from abroad that is extremely difficult and costly to obtain. Tadeco is audited yearly by foreign auditors. Certification from our own banana farm, not but also and health for workers. Our workers enjoy the highest salaries and benefits in the agricultural sector, such as medical coverage for the entire family, elementary and secondary schools, chapels, a hospital, recreational center, and facilities, as our communities in Tadeco are very sports-oriented, something that the management supports very strongly. but seeing is believing. Thus, we invite you all to see for yourselves the successes that the JVA between BuCor and Tadeco have obtained in the field of reformation or rehabilitation of prisoners, and likewise to see the productive, healthy, and happy communities of Tadeco. It is a glimpse of what the Philippine rural communities could be and should be. Thank you, Your Honor. Your Honor, may I add?
Mr. Valoria, is
Yes,
there
sir.
any other official from Tadeco who would like to make a statement? Wala na?
No, Your Honor. Thank you.
Okay, then may I now recognize Speaker Pantaleon Alvarez?
Thank you, Mr. Chairman. May I ask Mr. Valoria, how many hectares of land is Tadeco farming at the moment within the vicinity outside the 5,308 hectares subject of the joint venture agreement?
Good morning, sir. Right now, we have about 8,000 gross hectares, of which, 9,000 gross, 9,300 gross hectares, of which 5,308 is dapicols.
Okay, who owned the about 4,000 plus hectares in excess of the 5,000?
Your Honor, that's a combination of leased lands and owned land po.
Owned land by the company?
Owned land, yes, by the company, but very small already.
How many hectares does the company own?
With carp was 5 hectares, and there were also some areas that were industrial areas also, but very much smaller, sir, than our leased areas. I can give you a breakdown, sir, of the leased areas under our operation.
Within that area, there are industrial lots?
Well, not the industrial in the normal sense of the word, sir.
Mr.
but-
Valoria,
Yes,
let me remind you, you are under oath.
yes, sir. Industrial in the sense that it does that refers to the packing operations, not the agricultural land, but the packing areas. We have 16 packing plants where the workers. Where we have workers packing the bananas into the boxes, into the carton boxes, sir.
Are those areas duly classified as industrial areas, or they are still classified as agricultural lands?
They are considered industrial land, but still ancillary to the agricultural operation, sir, or necessary to the agriculture.
They have been properly classified as industrial land, meaning classified by the DAR as industrial lands?
Yes. Yes, sir.
And also declared in the real property tax declaration?
Yes, sir.
Okay, please submit to this committee copies of the titles of those lands as well as the tax declarations.
It will be our pleasure, sir.
Okay, thank you. Mr. Valoria, can you please educate us the meaning of a joint venture agreement as you understand it?
A joint venture is, as I would understand it, is a collaboration of parties toward a common objective.
A common objective. What is the common objective?
In
this particular case, what is the common objective?
Yes, sir. The common objective in this case is the rehabilitation and reformation of of the inmates of DPPF, sir.
As far as Tadeco is concerned, what is the objective of Tadeco? The primary objective in
course, sir.
entering into a joint venture agreement with BuCor.
Of course, the objective, of course, of Tadeco is a commercial objective. But the vehicle that we were able to PA, which we separate that from the commercial aspect of it, and we have a commercial objective indeed, sir. But the JVA is a
Okay. Is it clear to us that the primary objective of Tadeco in entering into a joint venture agreement with Tadeco is profit? Am I correct? The primary objective is profit.
The primary objective with respect to the JVA, sir, is the rehabilitation of the prisoners.
Mr. Valoria, do you have a copy of your articles of incorporation? The articles of incorporation of Tadeco. And can you please read the primary purpose of the corporation?
We don't have a copy with at the moment, sir.
I think we have.
But yes, indeed, I can assure you that what's stated there is a commercial objective, sir.
So it is not for the rehabilitation of prisoners.
Not in that manner, sir.
You just use the reason. Am I correct? Be honest.
I'm sorry? Yes. So JVA. Certainly, we are able to derive also a commercial advantage to that.
Okay.
And that, yes, sir.
So the primary objective is for profit. I think that is clear.
I agree, sir.
Because the primary purpose of the corporation naturally is for profit. Okay. Do you know the difference between a joint venture agreement and a partnership? Are they the same?
It's a legal question, sir, I think.
No. I don't think it is a legal question. I mean,
do I
you're the
know the
president of the
differences?
corporation. I think you have to understand the difference between a joint venture and a partnership, since you are into a joint venture.
That's a legal term, sir, but
Is it?
I would have to say that I would not know the details of the differences, sir, between a
meaning,
JVA and a partnership.
Meaning you have been claiming a joint venture agreement and yet you do not understand what a joint venture agreement means.
I understood what a joint venture means, sir,
Okay,
and
please.
I described it.
Please
and I answered
define
you earlier.
joint venture agreement. Describe to us.
As I said earlier, it's a joint undertaking of parties toward a common objective.
In the agreement, paragraph 2, section A, page 2, it says BuCor and Tadeco were to jointly create a monitoring committee. Was a monitoring committee created?
Yes, sir, there is a monitoring committee.
Can you please tell this committee who are the members of the monitoring committee?
May I refer this to Anthony Sassin, who's a member of the monitoring committee, sir.
Okay. Please, Mr. Sassin.
Thank you, Mr. Speaker. Yes, we have a monitoring committee. I head the committee for Tadeco, and the director here heads the committee for BuCor, sir.
Okay, who are the members of the monitoring committee from the BuCor?
The BuCor is headed by, sir, by the director here. And
Director?
Director De Los Santos. Right now, he's the one sitting there. The one before him was the director before, and he would bring his team, and I think what he does is he brings his administrative officer, he brings his accountant, and he brings his operation guy. He's here right now, Mr. Speaker, if you...
How often do the committee meet?
We meet quarterly, Mr. Speaker.
How often?
Quarterly.
Quarterly?
Yes, sir.
Do you have minutes of your meeting?
Yes, we do have, sir.
Okay. Please submit to us the minutes of your meeting.
Yes, sir. We would be very happy to do so, sir.
Now, does the committee has any discretion to make decisions regarding the operation of the plantation?
Well, that starts, sir, from the joint committee that meets monthly in the farm between a group from Tadeco and the group from BuCor. The head of the BuCor in the penal farm is here. He can say who his members are. These are people from personnel, people from operation, people from security, Mr. Speaker.
Yun bang committee, no, monitoring committee, meron silang discretion? Nagpa-participate ba sila in decision making regarding operation sa plantation, how it will be run, tapos doon sa pagbenta ng bananas, doon sa presyo, meron ba silang say doon?
Mr. Speaker, the job of the monitoring committee first on the level of operation. First, they talk about operation. Second, scheduling of people. The inmates occupy a position that is not very high because they change every day. That the BuCor decides who to field, who to bring, because for every 20 inmates, Mr. Speaker, there is one custodial guard. So that is done there.
So as far as this distribution of inmates are concerned?
As far as there is a committee, in the committee is one that is personnel, sir. One is security. One is operation. They tell you, before you operate, there's a roll call. They tell you what to do because there are different agricultural processes like bagging, deleafing, bud inject, canal operation. There's about 15 operations that has been done, Mr. Speaker.
Yung pagbenta ng saging, meron bang say ang committee? Kung magkanong presyo, kanino ibenta?
Hindi po.
Wala po?
Wala po. Yung benta ng ang job ho ng BuCor is to, since the packing stations are inside the BuCor, they monitor all the boxes coming out because you have a share per box. And there is a COA assigned inside the BuCor joint venture area. We comply with what is mandated in the contract as far as payment is concerned.
So, in short, parang yung papel ng BuCor, yung limited lang siya doon sa deployment ng mga prisoners. Tapos, pati yung pagbenta, wala siyang participation doon.
Doon po sa pagbenta, Mr. Speaker, hindi po sila kasali doon dahil meron tayong kontrata kung ano yung binabayad doon sa kanila. They just make sure that yung lumalabas doon eksakto dahil ang nagbibilang ho doon, sila po. As far as the operational concern, there is a level where they can participate kasi po masyadong technical and we cannot rely an operation that is too technical on that level. Pero kung sakali, sir,
pag titignan natin, parang yung BuCor, pinapayagan lang yung Tadeco para gamitin yung lupa. At saka, dahil nga doon sa agreement nyo, yung inmates ay pwede magtrabaho doon. Yung deployment ng inmates, yun ang minomonitor ng BuCor.
Oo,
Tama ho ba?
dahil pagpasok ho ng mga employees, sir, o yung mga trainees na papasok, meron hong mga detail kung saan sila ilalagay nung araw na yon. Kagaya ho sa mga regular employees namin.
Di ho ba sa joint venture agreement ay sa pagkaintindi ko lang po ay there na ako, ikaw, ang yung profits. Di ho ba ganon?
Opo, meron kayong pinapag-usapan kung magkano ang basihan.
Itong particular case na ito, yung guaranteed na binibigay nyo sa BuCor na 5,000, magkano yun? Per hectare ba yun?
Opo.
Ano po yun? Ano pong share doon ng BuCor? Rental ba yun? Yung 5,000 na yun?
Yung pong 5,000 yun, guaranteed rental po.
Guaranteed rental?
Guaranteed rental.
Okay.
Nung naimpisahan po nung 2003.
Okay.
Yun nung pinag-agrihan ho namin.
Okay. Tapos yung per box na share ng BuCor, magkano yun?
Hindi ko po matandaan kung ano yung 2003, pero meron ho kaming figure kung magkano po yun at meron tayong escalation.
Can we ask Mr. Valoria kung magkano yung share ng BuCor per box?
Yes, sir. The first amount is a production share, and then we have which started in 2003, and there was also a 10% escalation every 5 years, and then
So,
we have
magkano yan?
production
Magkano yan?
per box.
Per box, magkano?
Per box. The current,
1 peso?
which the rate per currently.
Yes, 2,000.
What's that? One.
Magkano?
1.8 per box.
One.
Centavos. Magkano yung kontrata nyo sa buyer nyo per box? Of banana.
I'm part of the reason also why the JVA is not or the BuCor is not involved in the pricing is that we have a long-term contract, sir, with Fresh Del Monte, and so the price is already stipulated in that contract. As we are party to that contract, we are.
Just answer my question. How much per box are you selling your bananas?
I'm trying to answer that question, sir, in that we are obligated to keep that amount confidential because of. No, let me finish, sir, please. Allow me to
You
finish.
know, Mr. Valoria, if you have a joint venture agreement with BuCor, with the government, walang transparent yan. Magkano ba
Exactly,
kinita
sir.
mo? Magkano?
Well,
Nalulugi na ba
The
ako?
concern of Del Monte would be that is that they have other suppliers, and they have, of course, the competitors. I'm very willing to give you the amount,
In
the
short,
price. I can give you the price, sir, but may I ask the committee to keep it confidential to them, because I do not have the authority to reveal it to the public. I can give you the price right now.
Okay,
but,
please submit it to the
confidentially.
committee. But, okay,
Yes, sir.
let me ask you this.
Yes, sir.
In your knowledge, no? Magkano bang binibili ngayon ng isang box ng banana? Export price.
Export price anywhere between sometimes it's less than $1, and sometimes it's on the very good times for the China market. And by the way, sir,
Average.
I wouldn't say that there's an average. The Dole farms have their own price, which is definitely lower than the price I will give you.
Range.
A range, as I said, maybe $1 to a very high in the China market. That's only achievable in the China market would be about $9. And that swings wildly in the China market. For all the other,
Figure, ah?
sorry?
You're sure of your figure?
Yes. The China market is principally a spot market price.
Assuming $5. So you give the owner of the land only 1 peso and 35 centavos?
That's not
1
correct,
peso
sir.
and
Like we
80
said, I
centavos.
said earlier, we paid actually in 2016 142 million pesos. 142 million pesos to the BuCor, which is a receipted amount.
Are you talking of the rental?
Oh, I see what you mean. Yes, sir. Yeah, going back to the rental.
Rental, okay.
Rental.
So I think it's clear that it's not really a JVA. It's not a joint venture agreement. It's a rental. Am I correct?
I would say no, sir. It's a joint venture.
Yes, because the contract is entitled joint venture agreement. But in
And-
essence, it is a rental. Diba, wag na tayo maglukuhan. Ikaw naman. Magagalit yung mga congressman dito, niloloko mo.
Sir, Your Honors, we come here in all honesty and all sincerity to answer your questions. There is a rehabilitation component in this JVA, and that is the reason why this is a JVA. Indeed, we have our own, Tadeco has its own objectives, the BuCor has its own objectives, and we defined a common objective in this joint venture agreement.
In your knowledge, magkano doon sa
Swings between pesos, our
You're the president of Tadeco.
Yes, sir, I am, sir.
A while ago, the speaker asked you about the principal purpose of Tadeco. Nowhere does it involve helping inmates of BuCor. Articles of Incorporation, meron po tayong principal purposes, merong secondary purposes, correct? Doon sa principal purposes, walang sinasabi doon ng Tadeco ay naging korporasyon para makatulong sa mga preso.
Sir, as I mentioned, Tadeco is indeed does indeed have commercial objectives. Tadeco has its own objectives, the BuCor has its own objectives, and we got together, or the two got together for a common objective under the JVA. There are two separate objectives for the two separate entities, and there's a JVA for a common objective.
That's good. At least tinamin mo na ang BuCor exists para sa mga preso, just as Tadeco exists for the profit aspect of its operation, correct?
That is correct, sir.
Okay. Wala na dito si Secretary Mariano, ano? Doon sa lugar ninyo, magkano ba ang partehan between a landlord and a tenant? Sharing system.
I'm sorry, sir, I'm not aware.
Is it, wala na rin di. Well, would it be safe to say that it's one-third goes to the owner of the land, two-thirds go to tenant?
I have no idea, sir, about tenants.
Okay. Sinong abogado mo dyan? Wala kang kasamang abogado?
I do, sir. I have the Tadeco's chief legal officers here by my side, Attorney Banga, and we have also our counsel, Attorney Panos.
Meron kayong abogado. Sinong, who is the lawyer here?
They're both lawyers, sir.
They're both lawyers. Your lawyers would agree that there's a principle in law that nobody is supposed to enrich himself at the expense of another. Is that correct? I'm asking the lawyers.
Yes, Your Honor.
Okay, so settled masyado yan. And your joint venture agreement started 1969?
With respect to the 3,000 hectares, Your Honor, that's correct.
Okay. And that is already 48 years ago.
Yes, Your Honor, that's on record.
It's almost half a century.
Yes, Your Honor.
And BuCor or the government gets only 10% net. Is that correct?
%? No, Your Honor, because under the recent joint venture agreement, there is a guaranteed annual production share plus the profit share, Your Honor.
All in all, how much does BuCor get?
May I answer that, sir? Yes, it's a commercial aspect. We paid the BuCor in 2016, 142 million, sir.
So magkano?
142 million pesos.
No. Percentage-wise. Percentage-wise.
Percentage of what, sir?
Saan ba yung 10% nakalagay?
Oh, no. The 10%, sir, that we were referring to earlier was the escalation clause. Was the escalation of the rates
Every
that
5
we pay.
years, nag-escalate by
10% po.
By 10%.
Yes, sir.
So as of 1969, ano ang share ng BuCor? Net?
In 1969?
Oo. Percentage-wise na lang. Hindi yung actual amount. Percentage-wise.
We will have to, your question, sir, is the amount that we paid the Bureau in 1969. We will have to check on the amount, sir. I don't have it readily with me.
Joint venture, gross. Last year.
Okay. We paid in Tadeco paid the BuCor in 2016, Your Honor. Last year, 2016, 142,719,662, broken up as follows.
Never mind the breakdown. 142 million. How
Yes, sir.
much did Tadeco get? Magkano ang tinanggap ng Tadeco? If BuCor got 142 million, magkano ang tinanggap ng Tadeco? Last year lang, ha? Last year.
Oh, sorry. I have the figures for the entire of Tadeco, 100%, but I don't have it broken down into the BuCor
Total,
area.
for your...
The grand total?
Yeah. 5,300 plus yung 3,000 something.
Income.
Meron ka bang figure for the 5,300 hectares alone? Wala? Okay, total na lang muna. Para umabot lang tayo sa dulo.
The question again, sir, please. The amount of money that we made?
Tadeco, for your use of 5,000 hectares plus, got 142 million last year.
I will have to, I don't have that amount, sir. We would have to call that out of the total amount that the company
Estimate.
made last year. Estimate. I have my Vice President for Finance here, and she will need some time to do an estimation, sir.
Ipambiya. Ang gross nga ninyo, hindi mo pa maibigay.
I said I'm willing to give you the gross amount.
Okay, how much?
For the total, but this is the total Tadeco, not only
Correct.
JV,
Sige lang, sige.
not
Magkano?
only JV area. The total gross revenue of Tadeco in 2016 audited amount was 7.1 billion pesos.
7.1 billion.
Revenues, gross revenue, sir.
Correct.
That's gross sales.
Ang net, magkano sa financial statement nyo?
Net income, oh. Net income of Tadeco is 552 million.
Okay. 582 million.
552 million, sir.
552 million. 9,300 hectares overall minus 5,300, masyadong lamang ang gobyerno dito. Siguro nasa sa lupa, 5,300, so nasa mga 4,000, mahigit kalahati ang ginagamit yung lupa that is owned by BuCor, correct?
That's about correct, sir.
Not about correct. That's correct.
Yes, it's correct, but not to the
Okay,
exact
now,
amount.
kung hahatiin natin ang neto mo na 552 million, at least magkano ang tatanggapin? 225 million ang tatanggapin ng gobyerno. Neto. Correct?
If you divide it by 2, yes, sir.
That is kung hati. Mahigit hati ito. So dapat nasa vicinity tayo ng 300 million. Ang BuCor dapat. Yung hating kapatid. Tama po ba yun?
Sorry. The total amount of 552 million is the total hectareage of Tadeco.
Which is 9,000
some 9,000
something.
Something, yes, sir.
Okay,
So,
9,000 divided by 2 is only 4,500.
okay, so
And
yes, sir.
what you are using out of the 9,000 is 5,300 na ang may-ari ang BuCor.
Yes, sir. On the gross sectors.
So mahigit nga kalahati. Now, you have paid only BuCor 142 million instead of 300 million more or less. We are here in aid of legislation. Walang personalan po ito, no?
Yes, sir.
Nag-iisip lang kami kung paano namin maiaayos ang batas.
Yes, sir.
Kasi masyadong nalalamangan ang gobyerno, hindi na ito hating kapatid nga sa sinasabi ko kanina. Ay, ang pagkakaalam ko, matagal na ang magsasaka versus landlord. Ang landlord ay 1/3, matagal na yun eh. Siguro, ganun pa rin yun. Wala naman ako naririnig na 1/4 lang tatanggapin ng landlord. So, kung nasa 10%, kulang ng 20% at 30%. But kung sa neto, titingnan natin, out of 552 million versus 142 million lang ang naibigay nyo sa BuCor. Mga abogado mo, ang unang tanong ko kanina sa kanila is, alam nila, ang basic principle in law, nobody must or can enrich himself at the expense of another. Dito kitang-kita, Tadeco has enriched itself at the expense of BuCor. Yun lang
Sir,
po,
sir.
Mr. Speaker, Mr. Chairman.
Yes, you're recognized.
Thank you, Your Honor. The 550 million refers, net income refers to the entire 9,000 hectares operated by Tadeco. but only 5,000 hectares of that is owned by Dapicol. So we have to divide more or less, pursuant to your logic, Your Honor, we have to divide that 500 million by 2. So because only half of that 9,000 hectares, more or less, is owned by the Dapicol. So if we divide 500 million by 2, it's more or less 250 million if you follow your logic, Your Honor. And that 250 million income of Tadeco should be compared with the 140 million, more or less, that was remitted to the BuCor pursuant to the JVA, Your Honor. Just to clarify and following your logic.
And I have to clarify that 5,000 is not one half of 9,000.
That's correct, Your Honor.
And 142 million is not one half of 552 million.
Yes, Your Honor, but the 500 million, we'll have to divide it by more or less
Correct.
5 to 9.
You take the proportionate income, which is supposed to go to BuCor under the doctrine of nobody should enrich himself at the expense of another. Ilang percent ba talaga? Mahina kasi mga abogado tayo, mahina tayo sa math. Ilang percent ba ang 5,000 versus 9,000?
May I answer that? May I further answer that, sir? So, following your logic, sir, if the 552 million, let's say we take the percentage amount of the Bureau's land, let's call that 300 million, 300 million profit being gained or obtained by the JVA, that 300 million needs to also be split between the two parties of the JVA. So that would be actually only 150 million, sir.
Hindi po ganon. Kasi there's only one Tadeco, okay, cultivating 9,000 hectares, di ba?
Yes, Your Honor, but only 5,000 hectares of that pertains to Dapicol.
Correct. Correct. Yan na nga ang tinitingnan namin. Magkano ba ang dapat na ibabayad ng Tadeco sa gobyerno? Kasi 5,000 is 1,000 more than 4,000. Kasi 9,000 divided by 2 is 4,500, di ba?
That's correct, Your Honor.
Okay. So, mas malaki ng mahigit 50% ang ginagamit nyo. Yet, pagdating sa kita, iisa lang naman ang supervision nyo dyan. Iisa lang ang operation. From security up to lahat ng operations, iisa lang. But, the problem is, pagdating sa kita, 142 million lang ang sa BuCor, 552 million ang sa inyo, doon sa 900. Bawasan na lang natin siguro ng 200 million ang 552 because the 200 should correspond doon sa 3,000 ninyo, something. Still, malayo pa tayo kahit ihati pa natin. Even if you are using only 4,500 hectares, hindi 5,000 plus, 225 or 226 million versus 142 million, malaki pa ang sisingilin ng BuCor sa Tadeco under a just arrangement. I-atras mo pa half a century ago, kasi 48 years na tayo, talagang malaki ang ipupuno nyo para magkaroon tayo ng equitable bayaran in favor of the government. Yun lang po. Siguro nagkaintindihan na tayo sa puntong yun. Okay?
Thank you, Your Honor.
Thank you.
Thank you. May I recognize Representative Noel Villanueva, or rather acknowledge the presence, Representative Carlos Oybarreta. Upon the earnest request of Representative Harry Roque, we will have to suspend deliberation on House Resolution number 867, and we will hear the preliminary determination of House Resolution number 767, entitled Resolution to Conduct an Inquiry in aid of legislation on the alleged corruption and irregularities in the operation and business of PhilHealth. Representative Harry Roque.
Thank you very much, Mr. Chair.
No, we'll just suspend for the meantime.
Mr. Chair,
After the preliminary determination, we will...
may nakalimutan lang kasi ako. Mr. Valoria, pwede ba sa next hearing, dalhin mo lang yung financial statement nyo? Kasi hindi ko maintindihan paano naging 552 million lang ang kita mo kung 7.1 billion pesos ang gross ninyo. Yan lang po.
Mr. Valoria, can you please furnish the financial statement as requested by Representative Veloso on the next hearing? The next hearing will be on May 30. Representative Roque is recognized.
Thank you, Mr. Chair. Maraming salamat po for your kind indulgence. Alam niyo po kanina, ang buong akala ko by 11 pwede na magpa-present ng aking resolution. No? Pero itong aking resolution po ay para imbestigahan yung mga korupsyon na nangyayari sa PhilHealth. Bagamat ang PhilHealth po, ang pera nila ay galing sa mga miyembro, nung isang taon po ng para sa taon na itong 2017, nag-allot po ang Kongreso ng 57 billion para mabayaran ng premiums ng mga maralitang mga Pilipino nang sila ay maging miyembro ng PhilHealth. So ibig sabihin po, bagamat voluntary contribution to, public funds are being spent for PhilHealth and in the tune of billions. Ano ba ho yung mga korupsyon na nais nating imbestigahan? Well, marami pong modus operandi dyan. Nandyan yung tinatawag nilang medical mission. Naghahakot po yung mga PhilHealth accredited hospitals na magpapagamot, bibigyan ng konting pamirienda, at bibigyan ng mga kung anong mga medical procedures at mangungulekta po sa PhilHealth, no? In fact, napaka-iskandalo po ito. Lumabas na ito dati pa, so hindi ito bago. Pero bus-bus at jeepney po ang hinahakot nila para di umano ay magpagamot. Pero sa totoo naman, maraming hindi naman po nakakatanggap ng kahit anong medical assistance. Pumipirma lang dahil binibigyan ng merienda, no? Meron din po mga balita na doon sa Katarata, no? Marami pong mga hinahakot din ng mga pasyente para sa cataract operation, pero hakot lang po yun para makakolekta, wala na pong after operation services na binibigay para lang makakolekta yung ilang mga accredited na mga ospital, no? Now, meron din po mga ibang mga accredited PhilHealth providers na magbabayad ng premiums para sa mga pasyente ng 3 months para magawan sila ng mga medical services at makakolekta sa PhilHealth. Pagkatapos ng 3 buwan, wala na po yung premium, no? At ngayon po, may mga bagong schemes. Etong mga family pneumonia scheme po, no, nangyayari, hinahakot din ng mga tao at papipirmahin po sila na sila ay nakakatanggap ng serbisyo para sa pneumonia. Bibigyan ko lang po ng idea kung gano'ng kalaki po ang involved dito sa pneumonia scam alone. Sa pneumonia scam alone, 10.3 billion po ang total na ginastos para sa pneumonia scam alone at kailangan po nating malaman kung ilan dito yung house-show na pneumonia payments na ginawa ng ating PhilHealth, no? Pero lumalabas po talaga na meron pa nga bukod dito sa 10.3 billion, may mga overpayment pa for pneumonia scam na tumataginting na 2 billion sa 2016 alone. Bukod pa po ito sa mga tinatawag na serial admission scam at saka dialysis scam. Ang nangyayari daw po, nag-issue ng stop order para wag mabayaran ng mga providers at meron po tayong whistleblower na magtatayo at sasabihin na kinikikila ng mga providers magbigay ng 10% para sila mabayaran. So ito po ang dahilan kung bakit nais nating maimbestigahan itong PhilHealth dahil pinag-aaralan din po natin kung kinakailangan baguhin yung charter ng PhilHealth, no? Ako po ang principal author ng Universal Healthcare at para magkaroon po ng katuparan itong Universal Healthcare, importante rin ang papel na gagawin ng PhilHealth dahil kahit papano yung voluntary contributions na at mga serbisyo na binibigay ng PhilHealth, yan po talaga yung magbabayad dun sa mga serbisyo na hindi mabibigay ng gobyerno under the Universal Healthcare plan. Now, sino pong mga resource persons? Actually, nandito na po yung mga resource persons ko, no? So, nais ko pong basahin man lang ang mga pangalan nila kasi nandito na sila, no? Dr. Calic M. Macabato ng PhilHealth Arm, Dr. Masiding M. Alonto ng PhilHealth Region 10, Dr. Francisco Lopez, former PHIC board member, Dr. Gelbert B. Galicto ng PhilHealth, Dr. Maria Dominga Padilla, former Head Executive Assistant po ito ng Secretary of Health sa PhilHealth, Attorney Valerie Holiero ng PhilHealth, Dr. Ansam Mangobad ng PhilHealth, at Rosel Kaluwag ng PhilHealth. At iimbitahin din po natin ang in-charge sa COA sa PhilHealth para sa ating investigasyon. So with these preliminary facts, Mr. Chair, I move that the Committee on Good Government approve a full-blown investigation on these scams and corrupt activities in the PhilHealth.
Any second? The motion of Representative Harry Roque is hereby approved. We resume deliberation on House Resolution number 867. Deputy, rather Majority Floor Leader.
Yes, before we resume, I'd like to request our members that if they have any questions to be asked to the chairman of the SEC, please ask them now because I was the one who personally invited her here. Eh kung wala naman tanong, para ma-dispense na siya at marami naman trabaho ang Securities and Exchange Commission.
Yeah, Mr. Chair, just a few important points that I'd like to request from the SEC Chair. On the financials, of course, this is a corporation and they submit to you audited financial statements annually. Is that correct?
Yes, Your Honor.
And in fact, you have your own audit group within SEC that looks into the financials of any company.
Yes, Your Honor. We have the Office of the General Accountant.
Yeah. So this committee would just like to request for submission of pertinent documents covering the period at issue, if still available, so that there can be we can compare it against what is to be submitted to us by Tadeco. And I understand, I do not know if you have already linked up with the BIR on the matter of this financial statement submitted. Can you please clarify this particular point?
If you are pleased, the practice at the SEC is that we only accept financial statements which have been received by BIR.
Good.
Although there have been instances where we do verify whether the stamped receipt really came from BIR, because there have been instances when they would submit different statements. But we haven't looked into any of the statements of the corporations involved in this matter. But if Your Honor, we will also include that when we look into their financial
Yes, please.
statements.
So we would like to request, Mr. Chair, the submission of pertinent financial statements of Tadeco to this committee for the guidance of all concerned.
Noted, Chairman Umalim. May I recognize Representative Veloso for any question to Chairperson Herbosa?
Madam Chairperson, nagpangabot pa kami nito sa... Anyway, tatagalog ko na lang po. Yung... you were also with Accra, di ba?
Opo.
And nagpangabot tayo doon. Wala akong malala na isang corporation of the stature of Tadeco that would be operating at less than 10% net profit. Meron ba kayong observation dyan as chairman? As chairperson, rather? Na mga malalaking korporasyon operating at only for the purpose of earning only 10% of their gross income.
May I make clarification, Your Honor? The statement earlier that we made about 10% was regarding the escalation of the rates that we
I
paid
am
the
not
BuCor.
referring to that.
Sorry, sir.
At saka, you're not supposed to interfere in my interpolation of a resource person. Okay?
My
Hindi ka
apologies,
naman ata
sir.
pinagbigyan pa ng chairman. Okay? Ganito po. Itong mga natutunan ko when I was a corporate lawyer under Teddy Regala. May mga, normally ang return of investment magkano? Ilang taon? Madam Chairperson.
Well,
Normally.
it really varies from one corporation to another. There have been instances when some companies really operate at a loss, but for some reason would still continue operating. But it's really a given or assumption that if you form a stock corporation, that's really for profit. If you're going to operate not for profit, then you should form a non-stock corporation.
Exactly.
And the examples of which are associations, foundations, NGOs.
Exactly. So, if I will borrow money, say 100 million, to form a corporation, operate a profit-oriented corporation, that 100 million is supposed to be paid up in 5 years. Yun ang nalaman ko noon. Yung return of investment should be average 5 years. Yun ba? Is that a correct observation?
Actually, the companies which register with us, they're expected to go into operation right away. But presently, the law says that if you do not operate right away, you have 2 years within which to do that. Otherwise, we could revoke your registration. But in the proposed amendments to the Corporation Code that we're now doing, we are going to increase the period of time from 2 to 5 years. So I guess your basis for saying that 5 years is the normal period within which a company could realize a return is a good
I'll
assumption
make
po.
myself quite brief in my questions. Ito po ang direction ko. I cannot understand how Tadeco, with gross of 7.1 billion, will have a net only of 552 million for 2016. That's one. And number two, if you could please furnish us with the GIS of Tadeco for the past 20 years lang, hanggang kaya, 20 years. And also, Tadeco up to 92%.
As of the GIS of 2015, I think it's about 92.6%, 99.
99%.
92.99%.
And when I say Anflo, it is a separate corporation, of course. Okay. Yun lang po ang direction ko. Pinapaalam ko na po sa Tadeco kung ano ang mga tanong ko next time. Because again, I cannot understand why Tadeco, which had a gross of 7.1 billion pesos, would have a net profit only of 552 million. Ano ang mga magic na ginawa dyan? And this will be verified from the financial statements po. Okay? Salamat po.
Are there any further questions from the members to Madam Chair Herbosa? So, yes, Representative Bomino.
For lack of material time, I will now dispense my interpellation to the President of Tadeco and reserve it in the next hearing. Meanwhile, I would like to ask the good Chairman of the ACC. We have here documents submitted to the members of the committee. The GIS of Tadeco submitted to us is only up to 2013, and Anflocor is only up to 2015. May we know if, from your office, if Tadeco had been religiously complying with the annual submission of the GIS for 2014, 2015, and 2016, and Anflocor for the year 2016.
Your Honor, from all indications, they've been compliant every year. The problem is they file with our Davao Extension Office first, and then our Davao Extension Office would transmit copies, hard copies to us, and that's when we would upload it to our automated system for the public to access. And we'll be able to furnish you all the way from 1969 or when Tadeco or Anflo had been established to the present.
Okay, thank you very much, Madam Chair.
Any other questions from the members to Madam Chair Herbosa or to Tadeco? Madam Chair, thank you. Next hearing will be sent out accordingly to the resource persons that will be invited on the next hearing. Any motion to adjourn? Second? Any second? Meeting is hereby adjourned. Thank you very much to all the resource persons. Okay.
Congratulations, Mr. Chair. Mr. Chair, congratulations. Job well done.
Sa Occidental.
Pwede next time ba? Storya po itong...
Ah, oo.